Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit. I don't think that's him, Mark. I don't think that's him.
Yeah, I don't think this is the guy either. But what are the odds that, they're scooping people up outside of this
guy there.
the wrong guy, and the dog was biting him.
He roughened him up quite a bit.
All right, sorry about this. Man, did I sleep in. I got a text and Maya's live. Maya's live, where you at? So we're going to jump right in. We're going to jump in at 1.25 speed. We're going to catch up. We're about 7-8 minutes behind. We'll catch up in no time whatsoever. Good morning. Good Thursday morning. Happy Friday Eve. Oh, my goodness, it's early. All right, here we go. Give me just 1 second. We're gonna have this... Where are we at? Right. Okay, there we go. Okay. We're going to go ahead and fade this out. We're a couple of minutes behind. We're at 1.25 speed, so we're going to catch up really quickly. And then we'll go back to normal speed. But good morning. I'm going to have to sing happy birthday at the break. Here we go. Wow. It's early. I'm going to have to go comb my hair, eat breakfast on stream. I don't know. So where's our audio here? I'm not hearing any audio. Here we go.
Pat Crowell's being accused, and I believe before the jury comes in, you may be hearing from Mr. Altenberg for something.
Thank you very much.
Okay, so we're going to catch up. Don't spoil it. We've got 7 minutes to catch up.
Our corporate representative today is Dr. Richard Elliott.
We're expecting Maya to testify today.
I was provided an exhibit list. Did you all want to go over that at this point, or are there other issues we need to address?
Yeah, okay, Judge. On the list, the one that says 9/28/2023, the only ones I think we have left, well, I can't say that. 2065, you'll see Dr. Chopra's bill for evaluation of Maya's exception to hearsay. There's no requirement of a corporate representative, and therefore, we don't need to read the predicate for that. Its relevance is, under our theory, that all of these damages after October 7th or so are relevant and material and damages. So that goes to causation, but I don't believe it's a basis for exclusion. Would you like to go through sequentially?
I want to deal with exhibits to the extent that we need to deal with exhibits.
Yes, sir.
I like that answer from the
Would you like a
judge.
response to that?
Well, what is his bill? What's it for?
It's for his examination of Maya Kowalski.
During what time?
During the shelter action.
And after discharge.
Well, yes, and after discharge. He saw her again. The one after anything.
He wasn't a treating physician or a treating doctor, was he?
He was an examining physician listed here as a non-retained. Well, I'm not sure, but he's listed as an expert here. He was not a treating physician in the traditional sense of the word. There's an order, which is the next one down there, amended order authorizing examination of child by Pradeep Chopra. And if the court reviews the order, I believe it'll clarify why we want this in, because the court requested in the shelter action that a doctor be proposed in order to give some clarity. The judge also ordered that the Kowalskis are to pay for it and the travel costs. But the fact is that Dr. Chopra was not chosen by the Kowalskis, not even suggested by the Kowalskis. And so we wanted to put the order in, and we believe the bill for the evaluation of Maya that they had to go through because of Johns Hopkins malpractice in misidentifying this and then mistreating it is relevant material.
Judge, it was an examination ordered in the dependency action for the dependency action. So again, say the bill is not relevant.
I don't understand their objection.
Well, I don't understand why you're trying to move it in if he's not a treating physician of Maya Kowalski.
Well, Judge, virtually anything under our theory in the medical malpractice action, virtually anything after the date that we are allowed to raise the issue, any expenses that they had at that point, in our point of view, are damages because they should have never had to go through any of this. And as a result, having to pay for Dr. Chopra by court order in that action is a damage. That's why we believe it to be relevant.
What about Chapter 39 immunity? And you're seeking damages for an expense that occurred in the dependency action. I don't see how that's relevant to this case at this point in time. So I'm going to sustain the objection relative to 2065.
All right, the next one is the amended order authorizing examination of Dr. Chopra, and that is, of course, a public record.
Tammy, I'm sorry I missed your birthday shout out yesterday. I will sing to you today when we have a break.
Mila's mom, congrats on winning the internet. Gavel.
Yes, Mila's mom, oh my goodness. You are first in chat. You won the internet. You know the drill. You've won before. Repeat offender here. Congratulations on being first in chat. I'm sorry I'm so late. I did a very poor job of all that. Cake Smooth, thank you very much for recognizing Mila's mom as the winner. I'm still waking up. So with each one of these sustained objections from the defense, the defense is carving away at the plaintiff's case, and you can imagine that that same carving away is carving away at the amount that, should the plaintiffs win, they would be awarded, in theory.
So why are we trying to put this order in?
The defense is trying to portray the doctor as simply a hired gun, that he was chosen by the Kowalskis to serve as an expert witness in the case. That is not true. That is not the case at all. He was suggested, and he still doesn't know, and I'm not sure who suggested him. I assume it was Hannah Kirkpatrick or someone else of the doctors, but it wasn't us. And so if they are going to raise, as they appear to, the idea that he is a hired gun, hired by us for no other purpose in the underlying action than to be an expert witness, that's simply not true. As the court can read the order, there was a concern, and the doctor can explain this, there was a concern about...
we're playing catch-up from this morning. We're like 6 minutes behind. That's why they're talking a little bit fast.
A real expert, a true expert, not that ours aren't, but an independent expert, that had nothing to do with this and was not going to be contacting the parties. They were simply going to send records, and then he was going to do an examination of at Brown University. And that's what happened. And so I want to establish here, in terms of his credibility, is relevant and material to establish the means and reason for his retention, so that there's no attempt to impeach him or somehow cross-examine on a point that, according to the order, is simply not true, that he is a hired gun.
Email from Bianca Kowalski to Dr. Kirkpatrick dated November 17, 2016. Quote, do you have any contact with Dr. Chopra in Rhode Island? I'd like him to be the, quote, unbiased CRP expert, unquote. It was absolutely Bianca Kowalski that emailed Dr. Kirkpatrick suggesting Dr. Chopra be the, quote, unbiased CRPS expert, unquote. If they're going to suggest it, I'm going to impeach him with this email. It's just not true. Bianca found it and suggested it. I've got the email. I'm happy to approach with it if you need to see it.
Well, perhaps the better course here is to wait and see what actually happens before, if the hospital starts contending, then we can talk about it. But it sounds like that email then is also going to come in as well. So why don't we not for now, but if the circumstances warrant it, then we can address it at that time.
So then upon redirect, I guess, it will be time to discuss it, and I will not raise it in my direct examination. All right, so the next one, 2408, 1711 to 1712, the defendants have been gracious enough to withdraw their objection to that. This is a photograph of the next witness, Rachel
Hang on.
Young.
Okay, Does it just say withdraw objection?
At this point?
2408-1711 to 17.
Can we go down one?
So defense, you've agreed to those 2 pages? Yes, sir. Okay, the court receives 2408-1711 and 2408-1712. What's next?
2528-008, photo of Jack Kowalski.
Okay, so every place that says yes, am I supposed to go ahead and just admit them at this time?
That would be great.
we're saying that we have no objection to them being admitted, Judge. We do have some concerns that we raised to some. So it was hard to do. We're not objecting to them being evidence, but we had some concerns about them being published to the jury without context, and we mentioned that when we noted it.
Okay, well, for those that I see that are clean, I'm going to go ahead and admit them. So at this time, the court's going to admit Exhibit 2528, pages 8, 14, 21, 24, 37, 45, 70, 102,
it's a lot of pages.
115, 124, 129. With respect to Exhibit 2529, pages 5, 19, 26, 35, 39, 42, 69. With respect to Exhibit 2530, pages 43, 46, 61. With respect to Exhibit 2532, the court will receive page 1, page 26, page 39, with respect to Exhibit 2571, page 30, and
so
the court will also
here.
receive Exhibit
Looks
250.
like, Kyle is there as well.
Strike that. The court will receive Exhibit 2705. I think those were all that were clean. What's next? We lost Mr. Anderson.
Just make sure my expert came in.
Judge, if I can, do you want me to explain the objection to description comment?
Sure. Are we on 2529-058, or is this?
041, I think is the first. 2529-041. Because it's the same comment for all of them. Judge, really my concern is I didn't know what the court's intention was with respect to when the exhibits go back with the jury. Are they going to be giving this detailed list? If they're not, if the jury's not getting this description, then we don't care. But if this is a description that's going back with the jury, then we do.
Well, normally we don't send back a table of contents.
There's so much evidence that might be sending back a table of contents to the jury.
When we are getting to the point of getting ready to send the case to the jury, then I'm going to have the lawyers work with the clerk's office, because if we're only entering certain exhibits, we're going to have to be very clear what is in. And then perhaps what we could do is create a clean exhibit table for the jury.
I think they'll need one, Judge. I'm not disputing that.
But the ones that we've been working on would not, in my mind, ever go back, because there's lots of commentary on them that are not appropriate for the jury.
That was my concern.
So
if this description is not going back to the jury, then we'll remove the objection to description.
Okay, so the court at this point will also receive Exhibit 2529, page 41, 48, 61. I'm sorry?
You said 48. I think you meant 58.
Oh, I apologize, not 48, 58. So it's 2529, page 41.
I haven't seen the data on camera
yet.
yet.
Page 61. The court will also receive Exhibit 2571, pages 1 and 26, page 40, page 53. Court will also receive Exhibit 2604.
Can I, Judge, briefly, my understanding is it took care of the issue of 2603.
So I can receive 2603 at this time?
That's my understanding. They gave them ones with it right out.
Well, meaning they gave it to the clerk?
Yes, sir, sorry.
So court will also receive Exhibit 2603. That takes us now to, I guess there's an issue with 2703.
Well, Judge, again, we're not objecting to them being admitted. Our concern, and we wanted to just address it with the court, if they're admitted, does that mean that they can just go publish it to the jury? We're concerned that things will be published to the jury without context.
Sorry, I didn't realize I didn't have text on the screen.
So that was the discussion that I know with the courts.
And 2703 has to do with the 41 hours EEG room issue?
Yes, they're all clips from that time she was in the ED room?
It's 41 to 42 hours long, and we didn't want to subject the jury to that and to sit here and watch the entire thing. So we picked out the clips, and the defense has picked out some clips as well that they would like to show as exemplars of what can be seen in there. The jury will have it back in the jury room, can view it to their heart's content, but I really don't think that it is appropriate or...
Her issue just is when you are publishing it to the jury, as my understanding. You want to do it in context, maybe with a witness or...
Right, that's what I'm saying, Judge. As opposed to just playing it, the jury, and then replaying it again, and then commenting it again. That was our concern.
I can suggest, we're going to use it with Dr. Chopra, who's our second witness, and he's familiar with the tape. So what we'd like to do, if the court needs to do the instruction on video or photographic evidence, fine, but this is just simply me explaining in my question where it's from. Are you familiar with it? Yes, I am. We show it, and then I ask him, what if anything, significant about that?
Apparently I can sleep really well, Tommy.
I guess we'll deal with it at the time. I just don't know if it's relevant to Dr. Chopra's question.
Well, I'll go ahead and receive them, and then we can discuss publishing, but right now it sounds like it might be logical to publish it or pieces of it at this time. So I will receive Exhibit 2703, Alpha, Bravo, Charlie, and Delta.
Judge, if I could inquire one matter about that, is it counsel's intention to publish all of the, I'm going to call them grabs from the surveillance video, both the ones they like and the ones we like, or just the ones they like?
Mine are, I don't think it's a question of one likes or the other likes, it's the same evidence. These are the ones that we chose as most appropriate for this witness to comment on, as he's an expert in this particular disorder disease. And so these are the ones that best exemplify what he'll be commenting on. If they want to put on something in their cross, or whatever they want to do in their case.
I think counsel has answered my question.
I'm so sorry?
I believe counsel has answered my question.
Thank you.
He was asking, are they only going to show the parts of the video we don't like, or are they going to show the parts we do?
Yes, sir.
What's next?
There is one more, Your Honor. And discuss this with counsel. It's Exhibit 2116-001. It is not on the list provided to the court. We discussed this briefly this morning. It's the text messages between Aladis and Sally Smith.
Lots of text messages.
It's about...
There's 78.
It goes from 2489 to 24...
It's 10 pages, Your Honor.
Judge, we would need some time to look at this. They didn't tell us about this yesterday.
Yeah, but we're not going to deal with that until they've had an opportunity to look at it. So that takes care of the exhibits for now. What's the next issue we need to address?
Your Honor, we briefly discuss deposition designations. Only to the extent that...
Is it important for this morning?
It's important for next week, so...
So we can do it this afternoon?
Yes, Your Honor.
What's next?
Judges
I have a
plowing
issue.
through
I
this.
can wait till we break this afternoon.
I've got 10 minutes before I'm bringing the jury in, so is it something we need to address right now?
The one thing I would bring up, Judge, we provided Your Honor's office with a tape of counsel giving an interview to Court TV on a couple of occasions in the last couple of days. The immediate, I'd like to address the entire matter when we have more than 10 minutes, but the immediate concern that we've got is the question of the court's inquiry when the jury arrives. The court's been very diligent in inquiring whether they've spoken with each other or gathered outside information.
Would they want a
We'd like
gag order?
for that inquiry to include whether they have been approached by others, and if so, whether they have brought that matter to the attention of the court deputy. Because of the nature of the comments made by counsel during trial, we're concerned that the jury may be approached by someone who they know and who knows they're on the jury, and given information or given implications that may affect their deliberations or affect their attitude regarding the case going forward.
This goes back quite a while. The court may recall the defendant's chief counsel, as I understand it, trial counsel in any event, had a series of comments in the Daily Mail, which was then picked up. This was the Daily Mail of, well, it says July, 1st of July 2023. And in it, they reveal on the headline is, Maya Kowalski's mom, Beata, was fraudulently writing prescriptions for her daughter and faced charges before she killed herself. Florida hospital. And the court then had ruled, or was going to rule, eventually ruled, that there was no basis whatsoever. And we had informed the other side about this. So I don't know what counsel is worried about with this. I did give a comment to Court TV, but I in no way brought up any facts whether in this case or outside of the jury's purview. And so my comments were limited to how's it going.
What I hear Mr. Hunter asking for is he wants me, when I'm asking, my normal questions in the morning, he also wants me to ask if any of the jurors have been approached by anyone about this case, and maybe perhaps have you seen any media reports about this case?
That's correct, Your Honor. Yeah.
And that's just a standard, would become a standard question or questions.
I don't think there's any problem with that. I don't believe that there in any event is big wonders of Court TV. No offense to Court TV, but that was a joke.
That's a joke.
Then it sounds like there's no objection from either side for me to ask the standard, to include in my standard, have you been approached?
There should be no objection to that addition. That's maintaining the integrity of the jury.
Have you seen any media reporting on the case?
Tommy Jones, Keller, good morning. Good luck on your verdict watch today over there.
After we're through today, but that's covers for me.
Judge, I have one thing. I'm sorry.
Ms. Crowell went first, and then Mr. Anderson, you'll come second.
Recall, yesterday. Last time we were at trial, that the comment came in through Mr. Whitney's question.
What witness are we talking about?
I'm sorry.
Try to be in focus, even though I'm all blurry-eyed still. Damn. This is some hard fighting here.
Dr. Duncan.
Okay, Dr. Duncan. The question he started, and then the court sustained objection, was if the record shows that FK did complain to the doctors at the hospital of physical and sexual abuse on multiple occasions. We stood up, we objected, the court sustained our objection, and instructed the jury to disregard. We think that more needs to be done because, frankly, I just heard the word sexual, I didn't even take in the whole thing, but I read it, it made me more concerned, and we think that the court should instruct the jury that there are no claims for sexual abuse by the Kowalskis. Because this statement is that she complained to the doctors of physical and sexual abuse on multiple occasions, and at this point the jury may think, well, that maybe they just haven't been allowed to hear about it.
I think this is a conversation more than the 5 minutes we have left.
Understood.
Maybe we can address that this afternoon.
All right, thank you, Judge.
Mr. Anderson.
Judge, we have a PowerPoint. We sent it over to both the court and defense counsel. It has 3 pictures in it, and it essentially simply has a title, and then we basically told them all of his direct examination, and I would think they'd be thanking us. But now they object to it. And so, for instance, if the court's got it here, there's one that says...
I have no idea what you're talking about. Can you put up whatever you're talking about?
Sure.
Judge, I would point out this is for the second witness. That's in case you want to go there.
But Dr. Chopra is the second witness, right?
Yes, he's coming right up.
And the first witness is quick-ish?
Yeah, I hope so. Rachel DeYoung, who's a physical therapist.
Okay, here's the
you can show
here's
him
the PowerPoint.
The court. Go to the 3rd page, signs and symptoms of CRPS, or the next page. The court
why are we doing a PowerPoint in questioning?
Because it allows the jury in a case where the timing and the particular topic raised are important to make clear, so that the jury understands the different parts of the testimony, and they can read as well as hear what's going on. And so it is simply an aid in a complex case involving complex medical terminology so that they can better understand what's being talked about up there. I cannot see any prejudice to them, the other side, because, again, they've been given this, and he's going to testify virtually identically to this. And so that is a purpose, in our understanding, Judge, of a demonstrative aid, is to assist the jury.
Mr. Shapiro.
Yeah. My objection is not, there are some pictures in there that could be demonstrative aids. My objection is the language. I mean, the first page is him and his credentials, and then he basically is just writing out his testimony. He's welcome to testify to this. The words are not demonstrative aids. We object to the wording in it. If there's a picture that they want to lay a predicate on a demonstrative aid, they're welcome to. I object to all the language of it.
Here's my thought. Before technology, the old chalkboard,
right.
People would, during the witness would say something and the lawyer would write it on the chalkboard. That concept doesn't offend me. The concern I have is you have language already written out and the witness hasn't said these things yet. So I don't care if you want to use, as he's testifying, you write out something that is displayed to the jury, but I don't think it's appropriate to have his testimony written ahead of time and then he just reads off the PowerPoint slide.
he has a great deal more to say on each one of these topics, Judge, that he prepared this, not me. So this is not a situation where counsel is coming up with directions for the witness to testify. These are simply points to remind the witness and to orient the jury. And the other thing I would remind the court is, if there's any doubt in the court's mind, we deserve a little bit of leeway because on opening statement, they were allowed to give, I grant you there's some difference between opening statement and witness. However, they were allowed to use a demonstrative aid that had pure argument in it with graphs overlapping and statistics and things like that. That's not appropriate for opening. We objected at that time. The court overruled it. So in our point of view, if in the future we can't use demonstrative aids like this with witnesses, fine. But we spent a whole lot of time with this one.
I am, again, if when the witness says something, if you want to write it down on a technology and broadcast, that's fine. But it's not appropriate to broadcast what he's going to say before he says it. I don't know how else to explain it.
Then is it appropriate, because my handwriting is so poor and it will take forever to write these things up there, for the witness
The gentleman behind you, and I keep forgetting your name.
Dan Rice.
Mr. Rice.
Dan.
If he, I'm sure, can type, and I'm sure that his typing skills are.
He's got an Alienware computer.
We'll be able to read it, if that's the way you want to go.
We can do it that way.
If you want to use the overhead projector and handwrite it, you can do that as well, if you want to. But you can't broadcast his testimony and then have him testify from it.
What I was hoping to do is have him testify and then bring it up.
If he has testified to it, that's fine. But you can't broadcast it before he's testified.
Agreed, Judge. Agreed. We'll stay on this last slide before he finishes that area. And then we'll bring it up. If they have an objection, they can make it.
Okay, we're at
That's not going to work
see
very
Mr.
well.
Altenburn
That's not going to work. They're going to screw that up.
attention.
There'll be objections over that, mark my words.
On the motion in limine yesterday about the 2015 material, Mr. Anderson promised he wouldn't bring it up, and I appreciate that. It occurred to me when I realized Dr. Chopra was the witness that if we're not giving curative instruction to the jury, that maybe a doctor that wants to talk about the 2015 to 2016 period needs to be clear that they're not volunteer information that's standard of care or criticism of the doctors in the period between 2015 and October 2016.
As it is right now, I think we're okay waiting a day. If it starts to look like that's what's happening, then I'm sure someone's going to stand up and object, and then we can possibly write a curative at that point in time.
Thank you.
But I'm taking Mr. Anderson at his word that that's not going to happen.
My questions will not be addressed to that period, other than obviously in predicate for 2016.
Okay. Anything else before we bring in the jury?
I don't believe so, Your Honor.
No, Your Honor.
Bring in the jury.
All rise. Court is now in session.
Okay, we're quickly catching up here. Apparently, the two people behind the lawyer, Dan, and what was the lady's name? What did we say her name was? Was it Karen? I think that's Karen. Dan and Karen are pretty much running the show from behind the scenes. Dan with his computer and Karen with her organizational skills.
Good
morning. Everyone, please be seated.
We're slowly catching
Members
up,
of the jury,
guys.
I want to confirm
We're a couple
while
minutes
you were away, you
behind
did
still.
not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct? Okay.
What?
Was there a...
No, I'm good.
Okay.
Someone's
I'm
like
also
correct,
going-
one's like nope.
I understand. I'm going to now ask you what will become standard questions as well. I want to ask you, have anyone approached any of you about this case at any time since you become a member of the jury? Has anyone, okay. And have any of you seen any media reporting concerning this case since you've become a juror? Okay, thank you very much. Those will become standard questions during the days. Mr. Anderson, Mr. Whitney, who's Mr. Anderson?
Rachel Dion, plaintiff calls Rachel Dion.
Her name's Kelly. Okay, so Kelly and Dan. Kelly and Dan are our two heroes of the courtroom right now. I knew it started with the K, and Forgive me. I'm still waking up. I'm sorry. Hey, Zoe.
Face the card and raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Yeah, it was still a fail. I don't call that a win. Getting one letter right is not good.
Good morning, Mr. Anderson.
Please state your name for the record.
Rachel Dion,
And where do you live, Ms. Dion?
Venice, Florida.
And have you been called here as one of the physical therapists that worked with Maya Kowalski both before and after her visit to Johns Hopkins from October of 2016 to January of 2017?
Yes.
And I want the jury to know a little bit about you. Are you from here?
Yes, from here. I've lived here about 30 years.
And where'd you go to school?
I went to Florida Gulf Coast University for my bachelor's and then Kaiser University for the physical therapist assistant license.
And what did you study? What was that for the physical therapy, or was there other?
I studied for my bachelor's. I have it in exercise science.
Uh-huh.
I did 4 years with that. And then Kaiser was just focused solely on the physical therapy license.
Okay. And then when were you first licensed?
July 2016.
And incidentally, was that one of the first days that you saw Maya Kowalski?
Yes.
Well,
And
like
so
first patient?
You have been then a physical therapist for some 7 years. Is that right?
Correct.
And in your career, have you had pediatric patients from time to time?
When I was a student, we worked with some pediatric, yes.
As your profession progressed, did there come a time then that you were working more with older people?
Yes, yeah, being the demographic in the Venice and Sarasota County area, it gets a little older.
Okay. All right. And through the course of this, have you continued to keep yourself apprised of any innovations, new techniques, and, for lack of a better term, the latest news in physical therapy techniques?
Yes, actually now this is the year we need to renew our license, so we're in continuing education courses now. But yes, I do those every 2 years.
Okay. And so where do you work?
I work for a home health care company called Patients First Home Care.
Okay, and how long have you worked for them?
It just opened up, under a year.
Okay. And then prior to that, where did you work?
I worked at Aviana. It used to be Doctor's Choice Home Health Care, and then before that was Agility Physical Therapy.
All right. And how long did you work at Agility Physical Therapy?
I did many positions before I started working as a licensed therapist there, so the time blends. But I think as a physical therapist, I worked for a year.
Had you had a number of pediatric patients, pain patients, or, physical therapy patients prior to Maya Kowalski?
At Agility, we got a lot of students in soccer injuries, so I was used to working with children.
Right. And in working with children, how important is it, from your experience, that they trust the physical therapist?
I see a lot of when therapists interact and go by their emotions and not be too aggressive too quickly, that they respond better.
And so is the point then to make sure that the patient trusts you and knows you're not going to hurt them?
Exactly.
And have you found that that approach generally brings better results with the patients?
Absolutely, yes.
All right. So the first time, and I think we can bring up, that's the last appointment. Where's my first appointment? All right. Can we bring up then Joint Exhibit 1028-0023? And for the record, this is an Agility Physical Therapy and Sports Performance daily note billing sheet for July 29th, 2016, the day you got your license, I guess.
The other day after.
All right. So this is going to go back to the jury. This is an evidence, Your Honor. This will go back to the jury, but I wanted to take you through a few of these so that the jury had the breadth of what we were doing. Can you explain a little bit about these different areas here on the first and second page and what they mean?
Okay, so we have the assessment, which is basically how the patient is presenting, what they're feeling, how we're viewing their ability to stand, their strength. So we're looking at also her range of motion, what can be performed with pain, without pain, if there are any deficits in her strength and range of motion, and what we need to focus on first. And those would be, our short-term goals that could be achieved in 4 weeks, 6 weeks, and then the long-term goals, which is much farther out at 12 weeks.
And then, how did Maya Kowalski present to you on this day? How'd she look? How was she doing?
She looked very thin.
Mm-hmm.
Her heel cords with the Achilles, her calf muscles, very, very tight. So toes were always down. Very, very sensitive to leg touching. Skin mostly everywhere, very hypersensitive, but definitely on the legs and feet, for sure.
If you're aware, was this after the trip to Mexico and the ketamine infusions there?
Yes.
And was this after the series of infusions from Dr. Hannah she received over the course of the spring and summer?
Yes.
And so, tell us what you did that day and your assessment as you worked through it with Maya.
She tried very hard to do all of the testing, even though it was very painful. She wanted to have the most accurate test results with this first visit. That way we can plan our plan of care accordingly.
Did she appear interested in getting well?
Absolutely. Very, very, very committed.
Right. And what could she do and not do at this point, noting this is approximately, and for the record, this is approximately a month or so before she went in on October 7th to Johns Hopkins?
She was sitting up pretty well. In the very beginning, she needs some support with sitting, but eventually we worked to unsupported sitting. Her trunk and core were getting very strong, and eventually it led to upper arm strength, and that helped her a lot with sitting without her back supported, without any pillows on the side to prevent her from falling over.
Did you, was she still in a wheelchair? She still arrived in a wheelchair?
Yes.
And through the course of your treatments there, prior to the visit to Johns Hopkins, did she make progress?
Oh yes, prior to John, yeah. We made a lot of progress together, and I was very hopeful at the time because the infusions were going pretty well. She would still have her bad days and struggle, but she was very hopeful and very committed to what she was doing and tried absolutely every exercise I would throw at her.
And based upon what you saw, and again, these will be in evidence, but did it appear to you that Maya was getting close to getting out of that wheelchair?
Yeah, yes.
And was Maya excited in this end of the summer, beginning of the fall to get out of that wheelchair?
Very much so.
Did she like being in that wheelchair?
No.
Okay. And you were aware at this time that Maya had been receiving different treatments for, well, first, were you aware that she had CRPS?
Absolutely, yes.
Were you familiar with the symptoms of CRPS?
Yes.
Can you tell the jury whether Maya's symptoms, as you observed them, appeared consistent with your knowledge of CRPS?
Absolutely.
What did you note?
The hypersensitivity in the skin. Hers was a very severe case as it was global, meaning that it was in the arms, legs, trunk. So she would wear shorts a lot because she could not even tolerate any fabric on her legs. Sometimes there might be a little lesion on the thigh, pale coloring, cold skin, and grimacing a lot because any sort of movement is very, very painful.
Was she the type of child that would, leaving aside the CRPS supersensitivity, but was she the type of child that would, lack of a better term, scream bloody murder if it started hurting, or was she the type of child that was quieter and more stoic about it?
She definitely tried to be stoic as possible. Never screaming, a couple times it would have gotten bad enough, maybe tears in her eyes, but never screaming, never crying. I would never get her to that point, however.
And can you explain have you worked with chronic pain patients who are not receiving pain medication at the time they're going through it?
I have not met anyone not receiving pain medication going through CRPS.
But leaving aside CRPS, have you had experience with people trying to make it through physical therapy without any assistance for the pain?
I've had patients try to do it, and they can't tolerate it.
Does the pain inhibit the ability to perform certain of these exercises?
Absolutely. Anything from brushing your hair, washing your hair, rotating around to wipe yourself for the toilet, getting in and out of bed, those things.
Did you receive some medical records upon referral over to Agility Fitness?
Yes.
And I don't have them here in front of me. If you can recall, what did you receive?
From Dr. Hannah,
Okay.
about what his treatment was for her, what he wanted us to avoid as therapists, certain techniques that could make her condition worse.
Okay. Let me show you then what has been previously marked into evidence as 2793 and also 2794 right after it. And for the record, 2793 is a photograph, and then 2794 is an email, and I add 2794 to orient you as to the date of this photo. I'm sorry, it's 2408. God, these 2408 1712 and 2408 1711. Now, is that you there?
Yes, that's me kneeling down in front of Maya, getting her strapped in. If you guys aren't familiar with what this is, there's a thick cord and it's attached to a railing system that goes around. So if someone is not able to tolerate or stand up strong enough with their legs, with their full body weight, we can kind of adjust it, lift it up, almost like they would kind of be up on their tiptoes, to try to associate what it would feel like to have your feet on the floor without all of your weight pressing down on it, to try to slowly introduce that to her body and to the bottom of her feet especially.
So at this time in September 23rd, 2016, can you tell the jury looking at this whether Maya was going to be capable of getting out of that wheelchair and walking on crutches soon?
Yes, as you can see, we loosened her heel cords quite a bit, her Achilles, so if your calf muscles are so tight, your feet will mimic walking on high heels without any shoes on. So we were working on getting her heel as close to the floor as possible to get her feet flat, but you could see that right foot is still wanting to turn in and point a little bit because there was some tightness and definitely a lot of pain.
So, but was her dystonia, did her dystonia, that is the turning in of the feet, improve as you worked with her through the end of the summer?
Yes, we were doing a lot of gentle stretching, and she was doing some of that at home.
Now, I noticed her legs there are pretty thin. Mm-hmm. At this point, from the beginning, when you first started to work with her up until she went into Johns Hopkins, can you tell the jury whether Maya was putting on any muscle mass on her legs?
Yes, her thighs were getting stronger. You could start to see the tone in her thighs as we were progressing.
And as she did better, can you tell the jury about her mood? Did her mood improve?
Yes, she was much happier coming in, looking forward to the treatment. Even though it was very taxing, painful, she was getting some results out of it, and that's very motivating as a patient to keep trying. Even though it's hurting, it's worth it.
And in your time when you had a lot of adolescent and pediatric patients, did you have any parents that demanded to be with the child on every minute to more or less control the situation?
No.
And with Beata Kowalski, can you tell the jury if it was true with her as well, that whether she was trying to control everything, unusual behavior, or whether she was a normal parent?
Absolutely normal. Of course, in the beginning, both parents wanted a little rundown of what we were going to be doing with her, as they should, and they felt very confident and comfortable. And after that, I just saw Jack, and he would just hang out in the waiting room, and if Maya needed to look at him to see his big smile, he would have it, and if he saw us doing something really cool, like this, he would snap a picture, and
Okay.
it was really good.
All right. Let's see if we need to skip ahead here. All right, so let's jump ahead then to, I want to get the last one before, so pardon me for a moment here. Let's find the last one. There's 927. I did have these marked, but...
This is just ASMR, guys.
Let's
really bad at
turn
that.
to, if we can, Joint Exhibit 1028-009 for the record. This is a daily note and billing sheet dated September 27th, 2016, and depending on whether September has 30 or 31 days, I think 30, then this would be approximately 10 days before she went into Johns Hopkins. Was this the last visit with her?
I believe so, yes.
And so, tell us again, right before she went in.
What's the zip number?
Exhibit number 1, it's got it marked here, 1028-0090.
I have that up.
Okay. Well, that's it. 927. Yeah, that's it. Yeah, that's it. Okay. Well, we've got it up. So I'd like you to review this, and then in a moment we'll turn to the second page. And
I wonder if they're
so
concerned
you've got
about this.
there the under current complaints and prior levels of function, current functional, all of that. Are these aspirations? In other words, what you're trying to get the child to do?
Yes, this is the goal. Her goals.
So where it says, for instance, maintaining body position and remaining standing, is that an indication that she was actually doing it, or that was the goal to do it?
That was the goal that we set up, to get those muscles stronger to eventually be able to achieve those goals.
Let's look at the next page, 1028-0091, and that's the second page of this. And tell the jury what's going on here.
These are all the exercises we would do, but the deferred today is what we avoided. So instead of me erasing all of that, I would just kind of grab it and see what I did last time and how she responded to it, if there was anything I needed to remember. But as you can see, she was doing some tall kneeling balance. So that means she is on her knees, not her butt resting on her heels, kneeling and able to control her trunk.
So that means she could kneel up on the bed.
Yeah.
And if there's a video later of Maya kneeling up on the bed, she had gained that much strength to be able to do it?
Yes, and a bed is difficult because it's soft. So there's a lot of give, and your core needs to engage to avoid falling side to side.
Okay. Now, there has been some testimony here about Maya sitting what has been referred to as crisscross applesauce. Have you seen children, patients of yours or others that sit in this position? And can you explain to the jury why?
This position provides some relief on our low back. That's why we have a tendency to cross our legs when we sit. It kind of gives relief on the pelvis where it meets the low back, providing some muscular relief from pain, especially if you're uncomfortable. I've known a lot of adults do it as well as children.
Is this generally well known among physical therapists that sitting crisscross applesauce is not an indication of the child is doing wonderful, but more an indication the child has low back or upper leg pain?
Absolutely. She was just trying to get comfortable.
Okay. All right. And so completing this here, she has, turning to the third page, she still has some, what does it say, diminished AROM? Maybe you can help the jury with some of these acronyms.
The AROM is active range of motion. So what she can do on her own. She can physically take her arm and lift it. No one else is taking it and lifting it for her. LE is lower extremities, so that's your legs. And UE is upper extremity, your arms.
All right. So as of this date, were you feeling positive or negative about Maya getting out of that wheelchair and returning to a semi-normal life?
Very much so. That was very helpful. We were going strong, and she was doing very well. The kneeling was the big next hurdle, and she was doing that excellent. She had her core strength improving, her trunk control. She was doing very well.
All right. And so I'm looking for over the course of the rest of the year, did you see Maya? Did you see her? When was the first time you saw her, if you recall?
When she came back after after she was in the hospital.
Okay. And I have a feeling there's one before this. I'm sure someone will point it out. But I'd like to take you to Joint Exhibit 1028-0093, which for the record is that billing sheet 01, so January 17th, 2017. Let the record reflect that Maya was discharged from the hospital on January 14th, 2017, approximately, 3 or 4 days before. So this is your first time seeing her back?
Yes, and this will show just how motivated she was. A lot of us would have probably wanted to take a lot more time off, but she was in there days after everything she went through.
Threw herself into it?
Absolutely. She's very committed.
But tell the jury about the difference in physical condition, as you saw it from a physical therapist's point of view, from the last time you saw her before she went into Johns Hopkins and as she literally had just come out of Johns Hopkins.
She seemed much, much thinner than the last time I saw her, especially her legs. There was a couple of abrasions on the thighs. Her pain was through the roof, very distant, very difficult to communicate with at the beginning because she doesn't, she's fearful of opening up, fearful of the consequences.
And so, did you notice whether her dystonia had returned or not?
Yes, it was worse. Although the stretching that we did for her calf muscles, Achilles, the heel cord, tightened up. Again, maybe even a little bit worse than when we first started.
Okay. And so on the pain scale there, I see partly down, she's describing worst 8, best 5, current 7. Orient the jury to what that means.
So that's the pain scale. 0 out of 10 means you have no pain at all. 10 means that you can punch your injury and it won't hurt any more than it already is. So 8 out of 10 is very high.
So at 5, was this a good day for Maya?
I would say that was about medium.
Okay. All right. And what else can you tell us about Maya's upper body? Did she need assistance to stay upright in the wheelchair?
Yes, she was slouched to the side, so you need pillows to support, otherwise you risk, skin breakdown. So Jack was very good about making sure she was turning, that she was offloading those bony prominences on the side of the wheelchair, because she was also very, very skinny, much skinnier than when I last saw her.
How about the circumference of her thighs and then calves? Had it increased or decreased?
Decreased.
Significantly or just a little bit?
I would say moderately.
All right. And in terms of range of motion, did you find that she had diminished in terms of her ability to move?
Yes. Before I saw her, she had deltoids that we would all be jealous of. Her shoulder muscles were so defined, and she was so strong. She could walk on her hands probably if she wanted to. But when I saw her again, everything was very, very weak. No tone left in the shoulders.
Mm-hmm. And in terms of the ability, for instance, to raise her arms, was that increased or decreased as she came out of Johns Hopkins?
Decreased range of motion.
And did you go through all of the standard evaluations as a physical therapist to assess her state at that point?
Yes, Alan did that.
And so you set about, I guess here, a chance to bring her back, if you will. Is that right?
Oh, yeah.
Okay. And so, again, what did you notice about Maya in terms of her tolerance of the pain she was in? Did she reject a lot of exercises, or did she just try to gut it through best she could?
She would participate in everything I asked her to. The only reason if I would change something is if she was grimacing pretty significantly and that grimace wasn't going away. I would maybe change her body position, maybe change the exercise, but still work the same muscles. And so it would still give her some strengthening without excruciating pain.
So throughout the therapy, you were constantly looking for signs she was in pain and would then adjust?
Yes, if it were appropriate pain, or if it were pain that she's not going to want to ever come back to see me again.
We're caught up now.
And you said before that
she slowed down
she had
just a
some,
tiny
and I forget the term you used, but the jury's interested to know, did you note any lesions on her?
Yes.
And where were they?
The upper thigh.
And what did they look like?
They were small, round, a little red, irritated.
They look angry?
Yeah.
All right. And were there parts of her body that were even more sensitive than when you had last seen her in September of 2016?
Significantly, her feet, the legs, below the knee was very excruciating, and it was sad because we made a lot of progress towards getting those feet introduced to some light touching and to some contact on the floor. She was getting very close to that.
And so you continued to see her then through January and into February, and let's see, the last one I have is on August, I think, of 2017, and at this point, some 7 to 8 months later, were you able to bring back some of Maya's? My question is, she had a certain level of fitness and ability to do things before she went in. Were you able to bring back all of it, a part of it? Where was she by 9 months?
She was back to tall kneeling, doing some dynamic balance exercises, which are movement exercises without having support, without a hand on the counter or something that'll stabilize you. So I would throw balls in different directions and she would catch it and be able to come back to the starting position in the kneeling with her tall kneeling. So core and upper body strength was doing great, and we were tackling the legs next and their tolerance to weight bearing.
And so in terms of the the levels of pain. Was Maya still in pain?
Yes, always.
Did you have to adjust your techniques from time to time so that she could continue a particular exercise or part of the body?
Absolutely, yes.
Can you give the jury some examples of what you would have to do if you saw Maya grimacing about a certain exercise?
Yes. So if she were sitting up performing an activity or kneeling and her body position wasn't cooperating with how her pain was coming in from that movement. So I would maybe make her lie down, do something against gravity, working out those same muscles, but having less pain throughout that.
And from what you saw, although there may have been areas where more or less, did Maya appear to have pain over most of her body, with different areas more sensitive than others?
Yes, the legs were much more painful than the arms. In the beginning, everything was very, very painful. And then the arms were getting a little bit stronger. Her range of motion is improving, able to lift the arms over the head. So then that opens up grooming. She's able to help groom herself. She has some independence there.
But still not out of the wheelchair by this point?
No.
But hopeful, trying to?
Absolutely.
Okay. All right. So at that point she left your care, and can you tell the jury whether this is unusual in terms of once you have worked through a period, and why?
Yeah, very unusual. I care a lot about my patients, so when they disappear, it's a little shocking, especially with how hard Maya and I were working together and the progress we were making with her treatments by the doctors. They were able to help her get stronger by the treatments they were doing to help get that pain level down, still there, but able to achieve the exercises that we were trying to do to get her stronger.
Did you subsequently learn that Maya was attempting to do many of these exercises on her own at home?
Yes, home exercise program. So if any of you have been in physical therapy, you should always get a sheet with your first visit of exercises to do at home. And because if you don't do them every day, the physical therapy won't work as well. So she was doing, especially I wanted her to emphasize stretching the heel cords, and that would kind of also hide in some tactile sensitivity, getting used to that with her feet. I was trying to stretch them so she would have contact with her feet and try to introduce some sort of sensation on her feet without excruciating pain.
And I believe, if you have reviewed them, that in the records for ability fitness, those exercises are set out?
Yes.
I'm trying to find them, but we'll let the jury look through them. Now, I noticed one other thing, and that is that from time to time you had something called a patient outcome. And if we could show an example, this one's fairly early, this is before Johns Hopkins, 1028-0041. And then, of course, it would be 0042. All right. So the jury's back there and they want to look through this and educate themselves further on how Maya was before and after. Take them through what this is for.
So this is for activities of daily living. How is she able to accomplish those things, if at all? So we would rate that based on a number.
Got it. A 1 to 10 scale again.
I'm sorry?
1 to 10 scale?
Yes.
Okay. And then, now this was obviously before, on August 17th of 2016, but at that time her pain level was still an 8 on certain days?
Yes.
And she had like moderate difficulty lifting an object like a bag of groceries?
Yes.
But overall, did she appear to be doing better despite her scoring there?
Yes.
Do the patients become more, when they're filling one of these out, do they tend to be more pessimistic than what you're hearing, or optimistic? Or how would you describe it?
I would say it's per patient, but Maya was very accurate and she's very intelligent, and she would want everything as accurate as possible. So told her not to embellish, or, if it's bad, tell me it's bad.
Okay. And so then by the time she left you, can you give the jury some idea of, just an estimate of when you were hoping she could get out of the wheelchair?
Before the hospital or after?
After.
The goal was before school. So I think in August the school started. I'm not sure when.
September.
That time of year, yeah.
But she was not able to do that.
No. We were really close, and then the pain was just too unbearable, and I said, maybe by Christmas. And she's like, no, I don't like that answer. So she went home, and she said, that's it. And she put on her backpack, got out her crutches, and made herself walk in the home. And I believe that maybe she didn't want to put herself in such a vulnerable, such a high pain position, maybe in public, in the clinic at Agility. Maybe she didn't know how it was going to make her body, her emotions respond, and that's why she didn't want to do it in therapy. She wasn't sure. But at home, she has her creature comforts, her dad, her brother, maybe her favorite show. She can call a friend if she's having a really bad time with it after her experience, to try to walk. But she did very well.
Got it. Okay.
The attorney shuffling papers while
I gather overall you felt that the therapy was successful.
Yes.
And Maya was now working as hard as she could to...
Every day.
Every day.
Kathy, refresh your browser. It should be clear. I'll explain a little bit about this testimony and what they're achieving here, and I think they've done a good job of this with this witness, especially with no objections.
Tell us about asthma. When she came in, did you notice any, or?
She would have intermittent coughing, but sometimes with asthma, it could worsen with cardiovascular exercises, some jogging, things like that. We weren't doing high heart rate activities. We were focused on strength, balance, transferring.
Okay. Your witness?
Wow. No thank you, anything. It's just your witness. The problem is he shuffles papers to find his next question while she's answering, so he's not paying attention to the answers. It should be before noon today.
Please score.
You may.
Good morning.
Good morning.
My name is Howard Hunter. I don't think we've ever met.
No. Nice to meet you.
Nice to meet you. You are here today to testify as Maya Kowalski's physical therapist during a certain period of time, correct?
Correct.
And if I understand correctly, at the time you first saw her, you were still a student.
Mm-hmm.
Is that right?
Yes.
Okay. And then you became licensed almost immediately after seeing her.
Right.
As a physical therapy assistant, correct?
Correct.
Say yes or no?
Correct.
Okay. And then you're still a physical therapy assistant today.
Correct.
Okay. When you saw Maya Kowalski, had you seen any other pediatric CRPS patients?
Pediatric, no. Adults, yes.
You've seen some adults, but no pediatric CRPS patients?
No.
Have you seen any since?
I have had one adult with CRPS.
Okay. Have you seen any other pediatric CRPS patients besides Maya Kowalski?
No, I shortly after I stopped working in outpatient and went into home health, and mostly those are covered with geriatric, Medicare insurances, so I don't see a lot of pediatrics anymore.
And incidentally, when did you leave Agility Physical Therapy?
I'm not sure on the date exactly, but I think I practiced with my license there for a year.
So sometime in, let's say...
I think I started the home health position May 2020. Okay. Or, I'm sorry, May 2018.
Okay. Sometime after August of 2017.
Correct, yes.
So like a year or so later.
Oh, less than a year. I started May in my new job, so I finished out, I went through the fall and the winter and the spring, and then by the summertime of the next year, I was at a home health company.
Several months later.
Correct.
Okay. Let's talk about, if we could, some of the chart entries you've talked about. When Maya Kowalski first came in to see you folks in July of 2016, the first person to see her was Mr. Dalton?
I believe so. I think there was Carol Pierce, Alan Dalton, and another therapist that signed off on some notes that I saw.
Okay. And according to what I see here, you apparently didn't really see her yourself until August of 2016. Is that right?
With the evaluation, the physical therapist sees her first.
Okay.
And then I do the routine visits after that.
Okay, so let's talk for a moment about her patient outcome form. That would be 1028 2000 or 1028-14. These forms are filled out periodically during a patient's tenure at a facility. Is that right?
Mm-hmm. Yes.
So periodically, you folks have to update things to give benchmarks of how patients are doing. Correct?
Yes.
Okay. I've been in physical therapy. No others works. Okay, so
I've been a patient. I know how this.
If we can look at
profession
this
works.
form.
Interesting argument.
If I can see it.
That's my experience is equal to how
First
everyone's
question is
experience.
pain level. And that's a 0 to 10, right?
Mm-hmm.
And does that solicit how the patient's pain level is that day in the clinic?
Yes, we emphasize how your pain is right at that moment.
Okay. And then her answer was 8, correct?
Yes.
Okay.
Let me back up just a little bit,
And
guys.
then
Hang on
the
one
next
second.
question
We're
is
gonna
not on a
teleport.
scale of
Ready?
1 to 10, but rather 0 to 4, correct?
Yes.
And that's true all the rest of those categories, all the way down.
Yes, on the page, yes.
To that page, and then over to the next page, the same is true. Is that correct? The whole form from that point
0 to
forward is
4,
0
yes.
to 4, correct? Okay. So, not to belabor it too much, because the jury will have this to go back with them, but the number 1 is kind of an overview of all the activities the patient is doing, her usual work, housework, school activities, and it asks the extent of the difficulty that they're having or their ability to perform that activity, correct?
It's focusing on if you had a job, if you were in the working, if you were able to perform your work or household chores or attend school activities.
Okay. And the answer to that question on the 22nd was 0, correct?
Yes.
And if you look at number 2, her ability to go about her usual hobbies, recreational, sporting activities, etc., was a 2, or moderate difficulty, correct?
Mm-hmm. Correct.
And then getting in or out of the bath was 0. She just couldn't do it.
Correct.
And in fact, when she came in to see you folks in July of 2016, this was after Mexico and a number of trips to Dr. Hanna,
Mm-hmm.
correct?
Yes.
She had no ability to get in or out of the bathroom or walk between rooms in her home, correct?
Yes, no walking.
And then she could put on her shoes and socks with a little bit of difficulty, correct?
Yeah, I mean,
I can explain when
I
there's a
think
break, if
being
that's
in
all right.
Florida, I mean, especially kids, they wear their flip-flops a lot, so if she wasn't wearing, I've never seen her in tennis shoes. If she was wearing any shoes, it would have been sandals hanging off of her feet because she couldn't tolerate anything on it.
But what she rated was a 3 out of 4.
Right. So her
A little
ability
bit.
to put it on, not the ability to tolerate.
Right, okay. And then she was unable to squat at all, correct?
Correct, because she cannot wait there.
Right. And then she had a She had moderate difficulty at 2.
We're going to teleport back in time just a few
seconds.
seconds here, if that's all right.
Yes.
Hold on just 1 second.
And then the rest of these are 0, performing heavy activities, getting into
We're going
out of
back
a
in time.
car,
Ready?
walking 2 blocks, or certainly walking a mile she couldn't do, correct?
Correct.
And at this point, incidentally, she was wheelchair bound, correct?
Correct.
Then if we go over to page 102815, she's unable to go up or down stairs, stand for an hour. She had no trouble sitting for an hour, but she couldn't run or make sharp turns, or let alone hop, but she could roll over in bed, correct?
Yes.
Okay. So, but she couldn't run.
Here we go. We're backing up just a tiny bit. This will help me
Or
get
make
the audio
sharp turns, or let
lined
alone
up.
hop, but she could roll over in bed, correct?
Yes.
Okay. So, we look and we see that well, were you aware that in August, several weeks after that, she went back to Dr. Hanna for a number of ketamine treatments?
Yes.
Okay. And that followed a situation in which she was demonstrating low tolerance for half kneeling and trouble with pain and fatigue, correct?
Yeah, in August?
No,
Yes.
in July.
Oh, in July, yes. Yes.
Okay. So then she went back to Dr. Hanna for 3 infusions. Let me ask Clay to put up the next patient outcome form she filled out, which would be 102899. And let's compare those for a moment, if we could. Could we put up those side by side? Okay, so we've got 117 on the left, on my left, on the screen's left, and 722. I'm sorry, I'm giving you the wrong number, Clay. It should be 817, not 117. It should be 14 versus 41. We'll get to 99 in a minute. So we've got her patient outcome form from initially on the left, and basically a month later on the right, correct?
Correct.
And so we see that on the 17th of August, she still had a pain level of 8, correct? And she was still unable to go about any of her usual work, housework, or school activities, correct?
Correct.
And her rating regarding hobbies and so forth was the same, a 2, correct?
Correct, yes.
And if we go down this form, on the first page, we basically see that her responses to the patient outcomes on August 17th of 2016 are the same as they were a month earlier upon admission, correct?
Correct. It takes about 6 to 8 weeks for a muscle to gain in size. So 4 weeks, it's not going to be too significant of a difference.
If we flip over and we see page, and we compare the second page of July 22nd to the second page of August 17th, that would be page 15 versus 42, we see the same thing, that there's been no change, correct?
Correct.
Okay. Now, after that August 22nd encounter, or I should say on that date, was there some indication that on that day she was experiencing increased pain and having trouble doing her HEP, her home exercise program?
On 7/22 or 8/17?
on, I'm sorry, 8/17 was what I meant to ask for today.
Okay. So was she having difficulty doing those?
Yes,
exercises?
on 8/22.
She was still having some difficulty, yes. She had difficulty throughout the entire treatment, but she was still trying, and this test is mainly geared towards weight-bearing activities.
Okay. And then as matters progressed, were you aware of her going back for other ketamine treatments during your treatment?
Yes, yes.
Okay, were you aware she went back for one on September 22nd?
I can't remember the exact dates of her treatments,
Sure.
but
let me ask to put up number 91, 89 through 89, I'm sorry. And at this point, was she having some difficulty with still performing tasks of daily living and some increased pain?
I think her grooming abilities were getting better, so managing her hair, bathroom, what we do in the bathroom, wiping, things like that, washing her hands, I think she was improving there.
Okay.
By that time, by September.
Okay. Well, after that, she saw y'all, we see on the 23rd, and then on September 27th. Let's put up page 90 if we could. So on this date, she's complained of increased pain levels since her last treatment, and she's going for ketamine treatment after today's visit.
Okay.
See that?
Yes.
Before this visit, were you aware of her having any kind of relapse in her CRPS?
I can't remember.
Okay. But you can't remember that before this last visit that you saw her on, that she had a CRPS relapse in early September?
Yes. Yes.
Okay.
What was that noise?
Is that the relapse she had before she went into the hospital?
Yes, ma'am.
Yes.
Sounded like a tummy grumble from the
And
judge.
do you remember the circumstances of it or what caused it?
No, I wasn't there.
But you do recall, I suppose, the last time you saw her before she went in the hospital?
Yes.
Okay. And we see that she was having increased pain levels, and she was going for a ketamine treatment?
Yes.
Okay. Now, were you aware that she went to ketamine treatments on September 27th, 28th, 29th, and 30th?
I mean, I guess all I knew was after today's visit.
Okay.
I didn't know her.
So you didn't know anything about any of that?
I didn't inquire about her daily schedule, no.
Okay. So you weren't aware of an emergency room visit on the 1st of October or the circumstances that led to her being admitted to All Children's on October 7th?
I mean, I can't remember at the time if I found out right then or if it was a few days later after she went to the ER, if I found out then.
But to be clear for everyone's benefit, as of the last time you saw this young lady on September 27th, 2016, before she went into the hospital, I'm talking about last time.
Okay.
As of that time, she was still in a wheelchair.
Yes.
And she still had a significant pain level, correct?
Yes.
Okay. Now, let's talk about, if we could, when she came back on the 17th of January 2017. At that point, the initial evaluation was done by Mr. Dalton.
Yes, I think so, yes.
And he's a full-fledged physical therapist.
Yes.
He's your boss.
Yeah, he was. Yeah.
He was, at that time, I'm
Yes.
sorry. Not now, but he was then.
Yes,
Right.
he still feels like my boss.
Okay. Well, he was supervising what you did with Ms. Kowalski, correct?
Always, yes.
Okay. And at that time, when she came back on the 17th, she was still having pain level of 8, correct?
Correct.
And she was still wheelchair bound?
Correct, yes.
Okay. and she was still having difficulty with virtually all of her activities of daily living at that point?
I believe so, yes.
Okay. Did you actually weigh her, or was she weighed?
I don't think I physically weighed her. If it was done on the initial evaluation, I think it would have been on one of the...
Did you folks at any point ever speak with her physical therapist at All Children's Hospital?
I did not speak with anybody at the hospital, no.
Did you at the time, or as far as you know, did anyone from Agility ever look at the records from All Children's from a physical therapy standpoint?
Alan, I'm not sure if Alan had or not.
Let's just kind of hit a couple of high points here. Can you put up, please, 172?
Maya's on screen right now. She's got the blonde hair. She's sitting next to her lawyer. Her brother, Kyle, and her dad, Jack, are here as well.
Let's back up, if we could.
The witness on stand is the physical therapist for Maya.
February 28th.
Rachel DeYoung.
It's 153. And just focusing on current complaints and gains, she was adjusting the size for a wheelchair, had a new wheelchair.
Yes.
And the note indicates that her father stated that she was doing a lot better and was scheduling an MRI of the spine. Correct?
Correct.
And when she, up to this point, was she getting any additional ketamine or pain medication?
As far as I can remember, no.
Okay. And after she came back to you from All Children, she never got any of that, did she?
I don't believe so.
Okay. So let's go to March 16th. Put up 172. And if you look at the history there, it relates that the patient is doing online school activities daily and swimming regularly. Correct?
Correct.
And she's pushing herself in her wheelchair. Correct?
Correct.
And the history...
Hold on a second, Mr. Hunter.
The beeping?
There's a little beeper going off over there. Can you turn it off? I think it's off now. You can continue.
Sorry, Honor.
What was that? Was that in the jury box?
I think I better see.
Yeah.
I didn't hear that. That's probably...
Might have been like a watch alarm.
I heard it.
And by this point, which is basically 2 months after you saw her again, correct?
Correct.
She's pushing her wheelchair as a form of physical activity and exercise?
Yes. Yes.
And she's, the father was telling you folks that he sees her using her legs more, and he feels her exerting pressure when he picks her up to maintain her hold, correct?
Correct.
And he's seeing her with her feet flat sometimes without her knowing.
Yes.
Correct? That's making some progress, right?
Yes.
Okay. And then if we go forward once again for another month or so, I'm losing my place here, I apologize. If we go to April 18th, and we put up 204, we see in the history assessment that she's increasing her swimming, and her father reports that she's using her legs in the pool, getting stronger. Is that correct?
Correct.
And she's going out on the boat almost every weekend.
Yes, they would physically put her in there, but it would help her spirits to be out on the boat.
Okay. And this is 3 months after she came back to you folks?
Correct.
Okay. So once again, she is making progress.
Correct.
Okay. So if we go forward one more month to May of 2017, to Joint Exhibit 1028-240, There's an indication that she's swimming almost every day for several hours, or for hours at a time, right?
Yes.
And she's starting to scoot from place to place in their house to get around.
Yes.
And she's independently propelling her wheelchair for long distances.
Yes.
And she's able to do her own ADLs.
Yes.
To some degree with that assistance.
Yes, light ADLs, I would say.
Right. Grooming.
Yes.
So then we go forward another date, 7/6, which is 17 to 286. And by history, she's swimming in the ocean without issues, correct?
Correct. That was what was said to me.
And she's got a new bedroom set with a bunk, with a top
Somebody has
bunk
tummy
bed,
trouble.
and she's able to get up and down the ladder without help.
Yes, her upper body was extremely strong at this point. She could basically lift her up without using her legs at all. It was quite amazing.
Okay, and so, but she's also able to climb a ladder.
She would just kind of swing herself, just kind of use her arms and core and get up there on her own. She might use her knees instead of her feet.
But this is an advancement.
Yes, correct.
Okay. And once again, through this point, she's not getting any analgesia or ketamine.
No, I think she realized she was going to have to do this on her own.
Okay. Now, if we go forward one more time to the last time you saw her, on August 22nd of 2017, page 334, she indicates she's back in school. Very tired from using crutches.
Oh, that was when she went. Yeah, that's when I saw her, and I said maybe by Christmas we could start walking. And then when she went home and said, "I don't like what Rachel said," and she proved me wrong.
Okay.
And obviously, it was very, very taxing on her, because you go from using the chair every single minute of your life to not using it at all. You're going to be very fatigued.
And by that point, her father was telling you that she is no longer using the wheelchair.
Correct.
Okay. And you never saw her again after that?
No. I was glad not to. I was told her, get out of here, don't come back. Well, she had to come back for a discharge, but other than that, I just want to see her at school, at the grocery store. I don't want to see her in the clinic.
I have clients that feel that way about me, too.
So how in heck did they come up with parental abuse? Am I missing something?
When you've never seen her again since then as a patient. You were about her age, correct?
Oh, whose age?
Well, you were younger, and she was your only pediatric patient.
Yes.
Correct? Okay. Have you had a chance to talk with Mr. Anderson before you appeared here today?
Her lawyer?
Yes.
Yes.
Yeah, okay. And you met with him about your testimony here today?
Yes.
That's all I have. Thank you, ma'am.
We met by phone.
Yes. Oh, yeah, by phone, not in person.
I called you and told you were going to be a witness.
Yeah, that's it.
Much to your chagrin. The point is that when Maya went in, from everything you saw, all the exercises you saw, when Maya got out of Johns Hopkins care, was she worse off?
Yes, mentally, physically.
And
that was
although
the testimony. That was the reason for this
pain
testimony.
meds may not cure things, can you tell the jury whether it tends to increase the ability of a patient to do the work and makes quality of life more significant?
Objection, Your Honor. Foundation. Overruled.
Yes. When we perform our activities and achieve pain, it makes us not want to do those things. So with some pain medication, your suffering isn't as great, and you can achieve your activities of daily living. You can perform some exercises that will help get you stronger, and eventually and hopefully kind of take place of the pain because your muscle's stronger, and maybe you won't need the pain meds as much once you're at that point.
So doing it without pain meds means gutting it out?
Yeah, I'm unnecessarily so.
And I believe you testified before that from what you saw with Maya, her CRPS pain, the levels of it were periodic. Is that right? That the levels would differ depending on the which day you were asking her.
Sustained.
What, if anything, did you notice about any variance in Maya's pain levels? Noting she always had pain, but
They would vary in intensity based on activity, based on maybe events the day before, currently, emotionally. I'm sure when we're upset, our pain becomes worse. And if she was doing something particularly taxing to her that previous day, she could be in more pain the following.
nothing further.
Members of the jury, do any of you have any questions?
Let's see if we have any jury questions. Checked in with Ayden this morning. He'll be here soon. He's got some stuff he's doing. He's just taking him away.
Thank you so much.
Thank you for being here.
Ayden's okay. All right, so that whole testimony, everything she shared could be boiled down to that last little question from redirect.
Members of the jury, I think this is going to be a good time for a break. Let's try to keep it to 10 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. You see it. Can you come?
All rise for his exiting.
That's Maya right there. The testimony she gave was basically before she went in the hospital, she was doing well. She was progressing. She was building muscle mass. Her abilities to walk, to move, to lift herself, to take care of herself were improving. After she came out of the hospital, she had regressed in all those areas.
Issues that we need to address before we take our break. Anything, Mr. Anderson?
I don't believe so, Judge.
Bueller.
Okay, let's be back in about 10 minutes.
Okay, let's see. All right. So there we have a little bit of break now. So I have to do a couple things because I slept in this morning. I have to say a few things. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you all here today. Thank you. I'm sorry I forgot. I did not even have time to do that this morning. We have, to my knowledge, we have 2 birthdays. We do normally sing to people who have their birthday today. I have 2 of them on the list. And I have to own up to something that I completely butchered, and I'll do that in just a minute. But I've got Tammy Coleman, whose birthday was yesterday, and I just barely missed her announcement that it was her birthday. I'm sorry. And then I've also got Lisa Wilmot. Is there anyone else who has a birthday today that needs to be celebrated appropriately through song? And this is not a solo. I realize that I may only be able to hear me sing, but I fully envision everyone in chat joining in and singing with me. That's the only way this works. I wouldn't do it if it was just a solo. Is it just me or has the feed gotten blurrier? Is this one better? Let's see. That one a little better? I've got a couple of feeds that I can choose from, but okay. Any other birthday that needs to be celebrated? Because we speak now, or I will not be able to add you in. Let's see, I'm not hearing any. Statistically, I think we should have 3. I'm just saying we should have. We did say happy birthday to Buttercup yesterday. We didn't sing specifically, but it was Buttercup's, was it 11 month? Wasn't it 11 month yesterday? Let's see. I'm not seeing, it's my cat's birthday today, Moose. Should we fit, let's see, if there's no other humans in there that I will put humans above pets here on the birthday singing preference, because I think they will enjoy it more than the animals will. I think that's it. Okay, we're gonna kick it off anyway. Here we go. La 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 la. Happy birthday to you. Happy birthday to you. Happy birthday, Tammy, Lisa, Moose, and Autumn. Happy birthday to you. And Lisa as well. Lisa. Oh, wait. I got you already, Lisa. I saw a different Lisa. No, I missed one after all that. Let's see. We have, for everyone who's having a birthday today or roundabout today, if I missed you, I hope that you have a fantastic day. I hope that you get everything that you deserve, which is good, coming to you and more. I realize that there are a million places you could be to celebrate your birthday, and you choosing to be here with us is an honor. Thank you very much. It's not lost on me that you could be at Denny's getting a free breakfast plate. But no, here you are with us enjoying your birthday and getting sung to poorly by somebody who hasn't combed their hair in about 12 hours. So, I'm sorry. Happy birthday. Hope you had a great day. Maybe you got to sleep in like I did this morning. Let's see. Lisa Bassett says, me on the 17th. That's right. Happy birthday. I hope you have a good one. All right. So that was it. I was going to pull up on screen just a display because we're sitting here watching Judge Boyd to see if she receives the flowers. So I brought up the order that shipped to her, and I'm showing that they're delivering on 10/2, and I swear I told them on the 28th. Isn't 10/2 her birthday? I thought we moved it from her birthday to be earlier so it wouldn't interfere with all the other flowers that she's going to be getting on that day. Let me just look at this. I'm seeing I took a couple screenshots here. It shows delivery date 10/2. I don't know how I missed this. I thought I had it on the 28th. Let's see if I can zoom in here and show you. Let's bring this over here. Oh, let's switch to that one there. Okay. Tap it for a second. We'll bring this over here. Don't I have a third screen somewhere? There we go. Fourth screen. We'll just keep making virtual screens until everything works. All right, so I'm just going to make sure I don't put all my personal information on here. That's the goal. Okay, here we go. I think I'm good on this one. I'm not going to dox myself on this feed. Here we go. Number 3. There we go. Look there at the top. Delivery date 10/2/2023. That's what they should look like. And there's our enclosed card. It says, "Thank you, Judge Boyd, in appreciation of the thoughtful, fair, and caring way you administer justice from the RA community on YouTube." Signed, Recovery Addict. That's what we have coming to her. I believe we included Autumn in the birthday singing at the last minute. I added Autumn to it. We had Tammy, Lisa, Moose, and Autumn. So congratulations. Happy birthday, Autumn K. I was just the person who pushed the delivery button. You guys sent the money and said, "Here's what we want." We struggled over the choice. We ended up going with this one after we confirmed that she had a similar display on her desk and has received those type of flowers. So we believe there's no allergies, but that's where we went with. She still does have a lot of flowers on her desk. Monday is good. I asked the florist to deliver it in the morning of that day, so it should be there early on. Anyway, I apologize. I thought for some reason they were going to arrive today, and that was not the case. Okay. All right, so we have, let me go back to this one. So the picture's a little clearer. Let me see why that is. There we go. For some reason, it's defaulting to a lower resolution. So now It's a little whiter. We've got more saturation on the other one, but we'll stay on this one for a second and make sure I get the other one at the same level, resolution-wise. There we go. All right, now we're cooking with fire. Check this out. Bingo. That's nice and sharp. 720p. That's the best we can get. All right, Nicole P., welcome to the gallery. Let's see who else. We had Michelle Eaton as well. Welcome to the gallery. Both continuing members. Look at those new courthouse colors by their name. By gallery, we have, when we say welcome to the gallery, welcome to the jury, or welcome as an attorney, those are the different levels of monetary support that you can contribute to if you choose to on the channel. And also, when you do that, it puts your name in green on the screen. It makes you exempt from any chat restrictions as far as timing goes. You lose all the slow chat restrictions, and you also get a courthouse by your name, like Dale here has a courthouse that shows how long you've been a supporter of the channel. It gives you access to all the emojis and the fun things we have there, as well as the seat command, which enables you to take a seat here in this virtual court, which is reserved for you. At whatever position you have. And Dale, by the way, I love my RA family, so happily I found it. Thank you very much. 4 months. Appreciate that. If for some reason your phone won't let you, there's a link. You could type !gifts right there, and it brings up this link on the screen. If you click that and go to the channel or gift settings on this channel, you can move the slider to the right. That enables your account to receive gifts on this channel, as long as you're not a business account. There are certain types of YouTube accounts that can't be members or receive gifts. But so Becca, I was completely wrong. The flowers are arriving on the 2nd, on 10/2. So we have just a few days. Let's see, that's Monday, right? I just went to show everyone the picture of what the flowers should look like, at least what we envisioned when we ordered them. And I noticed the delivery date was not what I thought it was, so I apologize for that. But she does have a lot of flowers right now, so that's good. What's the story about sending flowers to the judge? Michelle, somebody in chat said we should send flowers to her. We were watching her court for a while and loving what she does there and how she administers justice in a fair and caring way. And she likes flowers. She likes purses. The purses cost a couple $1,000s each, and the flowers are significantly cheaper. And so we opted for sending her flowers instead of a purse. and purses are hard to choose. You can't just send someone a purse and expect they like it. But so we sent some flowers, and that's pretty much it. But it was at your request, the community here. Okay, lots of news. Oh my goodness, I wish I had started earlier this morning. So much news in the world of true crime. With let's see, was it Suzanne out of Colorado? Her remains were found. She's been missing since 2020. Her husband at one time was charged with her disappearance and her presumed murder. Those charges were dropped, and now they found her remains. So that just blew the door wide open. I think someone else was found alive and well yesterday as well. There's just huge things happening. I don't know. Does somebody know if there's a BK hearing today? We're waiting right now for and by BK I'm talking about Brian Koberger. That's the Idaho 4 murder. We're waiting for the judge to make a final ruling on cameras in the courtroom, which will impact all of us significantly. Because that will be the case to follow if there are cameras in the courtroom when that takes place. And I'm planning on being there for it if they allow cameras. Let's see. Unexpected day off today, says WeBug. Spending it with all you and my dear mama. She's taking a turn for the worse. Oh man. Any prayers or good thoughts are appreciated. WeBug, I'm sorry to hear that. Hope some prayers go out to you for those who are able to join. I appreciate that for WeBug and her mama. October 2nd is my 52nd wedding anniversary. Cindy Lou, that's awesome. Congratulations in advance. We're almost there. I think you'll make it. Oh, that's good. Let's see. Is there anything else that I said I was going to answer during the break? How long is the break? Usually about 10 to 15 minutes. I've got 50 things going on while I listen, says Wheeler925. Wheeler925. Does 925 have to do with silver at all? Curious, because 925 silver is typical. That's the jewelry grade of purity for silver generally. Okay, no BK hearing today. Next court date for BK is October 26th. I am hoping we get a ruling from Judge John Judge before that. He should be able to figure out this whole cameras in the courtroom thing in a month. Richard Allen, the Delphi, is it Delphi or Delphi? I'd say Delphi, Indiana case. This is all over the news. It most likely, Vicky, it most likely will not have cameras in the courtroom. Think of the content. Think of the victims. Oh my goodness, it just jumped out of my skin. Bailiff slammed the door with the mic on.
Are there any issues we need to address?
No, that's not covered.
Okay.
Don't push way hard.
How long do we anticipate this witness to go, since it's now 10:30 almost?
Direct examination should take approximately an hour, 20, maybe an hour and 30 minutes. I'll try to go through it as fast as I can. And then I don't know about direct. I would expect it to be approximately the same.
So an hour and a half.
So it sounds like we'll probably take lunch at the conclusion of direct examination before cross-examination.
Correct. And then we have, if we want to bring them back after lunch, we have now, the court's been hard-working and got us back. We have 5 depositions, I believe, that we can play. I certainly wouldn't put them through that, but we could probably use to have the afternoon as the court had planned.
I'm uncertain. Are you saying you just want to do Dr. Chopra today, which is what we talked about yesterday?
Yes, sir. I was just giving you the options.
I'm fine. That's what I assumed we were doing based on our conversation yesterday.
That's what we understood the schedule to be.
Yeah. Okay. And on break, the court deputy did say that the jury has asked that if we could tell them whenever we're going to have like days off.
Oh.
So my thought is I will tell them, we should be able to tell them tomorrow what next week's going to look like.
Okay. I would anticipate, despite our best efforts, that we will finish slightly early, maybe 4, somewhere between 3:30 and 4:30. It just depends on length of cross-examination.
Today?
No, tomorrow.
Okay.
Friday. So I'm sure they won't be upset getting out a little early on Friday afternoon.
Do we know who we're calling tomorrow?
Well, it's a number of them. We're still waiting for confirmation on a couple of them. Give me a couple, and we know.
So did they say they were or weren't going to call Maya?
Spiegel, Dr. Barr, you're going to know about those. Yeah, Dr. Spiegel and Dr. Barr tomorrow, and they're.
Are they confirmed already, or are you waiting?
Yes, they're confirmed, but our lay witnesses we're juggling, but we may know something by the end of the day.
So I thought at lunchtime will we know more? Okay.
We're doing our best.
Okay.
So possibly not Maya today.
Not before this witness.
They might have teased or just tormented the defense with that. So we know that Maya will testify at some time during this trial. At least that's expected. And yesterday they said that they were going to, because of a witness that was sick, that they were going to call Maya instead. But it looks like that is not going to be the case. Mics are off while the jury comes traipsing in. There they are. Yeah, they'll have to be really, really gentle with Maya. Wheeler 925, I have to say that I keep a mercury dime on my desk that I found metal detecting that I used to tighten my camera base down with.
Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct? Correct. Again, I'm going to be asking you these additional questions as well. Have you been approached by anyone about this case since the last time we talked? And have you seen any media coverage concerning this case since the last time we talked? Okay. Mr. Anderson, your next witness, please.
I'll call Dr. Chopra, Pradeep Chopra.
Dr. Chopra's plane came in. Let's see.
Just stand here, face the clerk, and raise your right hand.
Do you solemnly swear or affirm testimony about to give will be the truth, the whole truth, nothing but the truth?
I do. We're going to come this way. Bring a seat in the witness stand there. Sure.
Welcome, Doctor.
One moment, Your Honor. I want to make sure I've got an exhibit correct.
Here comes the ASMR paper shuffling. He said, one moment. I need to make sure I have an exhibit correct.
Please state your name for the record. I apologize. Please state your name for the record.
Pradeep, P-R-A-D-E-E-P, Chopra, C-H-O-P-R-A.
And have you been asked to testify here as to the condition of Maya Kowalski when you examined her in 2017?
Yes.
So I'd like to give the jury the benefit of some of your background, training, and experience. The first thing I'd like to start with, if we could, is your schooling. If you can tell the jury a little bit about that. First, what kind of doctor are you?
I'm supposed to be a pain medicine doctor, but I take care of medically complex patients, mostly with pain.
Okay. And where did you go to school, starting with college?
My medical school was at the Harvard Medical School. I did my basic training over there, and I did my residency in anesthesia and critical care, and then I did my fellowship in pain medicine.
And was this all at Harvard?
This is all at Harvard, yes.
How many years did you spend at Harvard Medical School and the Harvard Medical Center?
6 brutal years.
And do you often speak on the issues of CRPS and chronic pain?
I do.
Have you prepared different TED Talks or the same type on these issues, CRPS and chronic pain?
No, I haven't done a TED Talk, but oftentimes different organizations, various organizations invite me to give a talk. It's mostly to patients, and sometimes hospitals will invite me to give a talk to their physicians on CRPS.
I know that you have won several. Well, first, tell us a little bit about your family. You're married?
Yes, I am.
And you have how many children?
I have a child.
And I understand one of them has some challenges?
Objection, Your Honor.
It's predicate for his ability to...
I have a son, and he's a special needs child.
And so are you familiar with the challenges to parents for special needs children?
Yes, I'm very familiar with that.
I understand that you have won several awards over the course of your career for humanitarianism involved in medicine. Can you tell the jury about that?
Yes. There's a bunch of awards that I've won, actually.
Okay.
But for the humanitarian award, it's called the Compassionate Care Award. This award is only given to one physician in a year out of the entire country. and it's a very rigorous selection process, and they look at the patient if the physician is compassionate, has empathy, and many other things.
How long have you been in practice?
I started practice in 2000.
Okay. And are you board certified?
Yes, I am.
And what are you board certified in?
In anesthesia and critical care, and in pain medicine.
And do you have experience in pediatrics of any of these areas?
I do.
Tell the jury a little bit about your experience with pediatric pain management.
So of the 6 years that I spent in Harvard, about a year of that was spent at Boston Children's, where I practiced anesthesia, critical care, as well as pain medicine.
And so you had the opportunity at that time to see pediatric patients with pain, chronic pain issues?
Yes, I did.
Okay. And what do you do now? Are you teaching now?
I do. Well, I run the Center for Complex Conditions, which means I see mostly very medically complex cases, both adults and children, and I also teach at the Brown Medical School.
And Brown University is an Ivy League school?
It is an Ivy League school, yes.
And what do you teach there?
Same thing. I teach my students how to, I tell them that you're going to learn medicine all your life, but you need to learn how to be able to examine a patient, how to be empathetic to a patient, how to listen to them, how to understand what they're trying to say, and that's my job. That's what I try to teach them.
So you're a professor at an Ivy League school. Can you tell the jury the importance of a physician gaining the trust of the patient in terms of care and treatment?
Well, gaining the trust of a patient is to be able to, number one, the most important thing is listen to the patient. Take the time to listen to what they're trying to say. And once you listen to them, then you can, ask them some questions, get to know them better, even get to know their families, and then do a full physical examination, not just a partial examination, and then sit down with them and come up with real expectations. What are the real expectations? What to really expect, and what your plan is to help them.
Now, tell the jury a little bit about how you got involved in the examination and rendering opinions about Maya Kowalski.
I was back in whenever she came, I can't remember the year.
2017.
2017, I received a call from the court. And I can't remember whether it was the judge himself or somebody else from the court. And I was told that they needed me to examine a patient and give an opinion on that.
And do you know how or who recommended you to perform this examination?
I honestly don't know who recommended that because I wasn't really paying attention on that.
Okay. It could have been Biana Kowalski, it could have been one of the physicians involved, could have been any of the parties involved.
No, it wasn't anybody from the Kowalski family. It was not a physician. I know it was somebody had to do with the legal system. It might have been her attorney at that time, or it could be somebody from the court.
I see. And so, what steps did you take then? And ultimately, did you prepare a report which the record reflects is in evidence at 2005-001 through 2005-021. May I approach to have the doctor identify?
You may.
And is this the report you ultimately prepared?
Yes.
Now,
this is the report.
Okay, you can. We'll get it back in a moment. Now, so you weren't a formal, what's known as a CME or IME, but you understood that you were supposed to render a fully independent opinion?
Yes. So this call that I got from the court in Florida I was tasked with one job, and the job was to give my opinion about what was going on with Maya, and that was it. I was not going to be the treating physician. I was not going to take over the care, just give an opinion. End of it.
Got it. I forgot, you have some additional degrees. What is a MBBS?
MBBS is, so before you come to the US, you have to be a physician back in India. So I'm from India.
Right.
And you get a degree, it's called MBBS. It's a British degree.
Right.
And then you do your MD and all that again. So I went to med school twice.
Okay. And what's a DA? Is that similar?
I'm a doctor squared.
A DA is a kind of it's a diploma in anesthesia. It's like a mini training in anesthesia for a year.
And then MD and then MHCM. What is that?
That was from the Harvard School of Public Health. That was on Masters in Healthcare Management.
All right. And so have you worked in both hospitals and in private, seeing patients clinically?
Yes, I have worked in quite a lot of hospitals. Now I don't work in a hospital. Now I work in my own office.
Okay. Now, tell me what you first did. Tell the jury, rather, what you first did in your job, as you saw it, to survey this course of treatment, and then subsequently, I suppose, examine Maya. Tell them how you went about it.
Right. So, they sent me a boatload of documents. Scary.
A boatload.
That was scary. That was like documents like 5,000 pages. And but I don't review documents before the patient comes in. I need to make my own opinion first.
Why is that important?
It's important because I don't want my thinking to be biased by reading other people's reports.
Is there a problem in medicine with a diagnosis taking on a life of its own, otherwise known as a narrative?
Yes, it's a major problem. What happens is that one physician, maybe depending on his competency, incompetency, makes a diagnosis without any basis, and then that gets populated into the medical records, and then after that it's just passed on forever because no one wants to change that.
And so it takes quite a bit of gumption, for lack of a better term, to step in and change the narrative.
Objection to the leading, Your Honor.
Sustained.
What, if any, effort does it take to change the narrative?
It's almost impossible. I've had a few patients who have tried to do that, and it's extremely difficult.
But does that mean a doctor should just blindly follow a narrative, or should they give it an independent view, excluding a narrative?
So if it's a major diagnosis.
Thank you, Beth.
And it affects. So if I'm seeing a patient, and let's say that I'm seeing the patient for pain in their left knee, and they also have asthma, I'm not going to worry too much about the asthma part. I might say, hey, do you have asthma? And they'll say, yes, I do. But I'm not going to go into great depths with it. my focus would be more on the knee part then.
So you saw Maya first before you reviewed all those records?
Yes, I tend to, the way I work is I don't like to be biased, so I see the patient first, make my opinion, and then I go back and look at the medical records in detail, and then figure out where we are with it.
So I want to deviate a little bit from going through your findings, and I first want you to help us understand CRPS as you know it. Have you treated CRPS patients?
Oh yes, I have a lot.
Okay. Can you give the jury an idea of how many per year?
I actually did that calculation for this. Yes. So approximately 5 patients a week for 20 years, and the math came out to be about 125,000 patients in the last 20 years with CRPS.
My goodness. And have you yourself participated in any studies or surveys?
No, I haven't. You mean done research on it?
Yeah, or cooperated in providing patients for clinical evaluation, things like that.
No, I don't want to. I don't like to send my patients for clinical. They're already in so much pain and they're already suffering, and I don't do that.
Understood. So tell us now the signs and symptoms of CRPS that they can understand as we go through this and show photos that they should look for here.
CRPS is one of the few pain conditions that you can literally see. I mean, if I say I have a headache, you can't see the headache. If I say I have knee pain, you can't see that. But CRPS is one of the conditions you can actually see. And the diagnosis of CRPS is based on very clear rules and regulations. There's a whole checkbox, and you have to check certain boxes. And when you check a certain number of boxes, then you come to the conclusion that the patient has CRPS. So, for example,
no, please. I'm asking you to go through if it's okay.
Right. For example, obviously the first one is that the patient has severe excruciating pain and there is no other explanation to it. Nothing else explains it. That's the number one. Number two, the rest are kind of optional, and you have to pick and choose which ones you see. So one of them is there a temperature difference? So if I have CRPS in the left leg, and so the temperature in my left leg might be hotter or colder as compared to the right leg. The next thing is you look at color change. Oftentimes the affected side is either dark red in color, even blue in color as compared to the right side. You look for swelling. In the initial phases, swelling is pretty obvious. Later on, you don't see it as much. So you look for swelling in these patients. You look for skin changes. The skin may sometimes become thin and shiny, or they may develop small, tiny lesions, almost like blisters that are painful. They can develop that. They even develop hair changes. Some patients actually grow more hair, and some patients have less hair. It can be in the same side or on the opposite side. You can see nail changes. Their nails start to kind of break off. They get brittle nails.
And what about asymmetry in muscle groups from right to left? Is that an indication?
I was getting to that. So the last one is muscle symptoms. So do they have what's called dystonia? Dystonia is a terrible condition. So I'm going to show you. If I had dystonia in my left hand, it would be like a tight muscle, like the arm is taking a life of its own and it's cramping up. Or they may have tremor. So they may not have tremor when you don't do anything, but if you say touch them and then they start to have a tremor, They may have muscle weakness, they have muscle atrophy, the muscle starts to shrink. So there are many muscle symptoms that these patients can have.
I want to, if you could, and I think I wanted you to explain what really happens in CRPS, the central. I want you to explain what we know so far about CRPS, how it starts. Yes.
I just have one other clarification on
Go
CRPS.
ahead, please.
When I say that these patients have pain, we're talking about the world's worst pain. I mean, this pain is worse than amputation pain. This pain is worse than childbirth pain. The gentlemen on the jury won't understand that, I'm sure. This pain is so bad, so bad. The worst part about this pain is that, if I stub my toe, it looks like the world is going to come to an end. Okay? But I know that this is going to go away in a few minutes. But CRPS pain does not go away. It's there 24 hours, 7 days of the week, and it just stays on and on and on. And the worst part is that there's no known treatment to this. We try all sorts of things. Some work, some don't work. But this is such a this is often known as a suicide condition, because these patients, the pain is so bad, they can't sleep, they can't eat, they can't work. Their families don't believe them, because you don't think like somebody. The general impression is, oh, you have pain, take a Tylenol and it'll get better. This is not Tylenol pain. This is your hand in a hot stove. That's exactly what they described as. In fact, patients describe it as if their hand is inside a hot fire stove, and they can't take it out. That's the thing. So I just want to clarify that this is, when I say pain, it's not a small itty bitty pain in the joints.
And what is the McGill pain scale?
The McGill pain. So McGill University in Canada decided to see, like, okay, where do pain conditions stand? So they interviewed a bunch of people, and they said, all right, where in this scale would you put your pain? Like pain from labor or pain from amputation of a digit. And so they drew a scale, and that scale, CRPS was CRPS was way above anybody else. It was way above amputation pain, cancer pain, or even labor pain.
With your permission, Your Honor, I'd like to publish a photo of the McGill pain scale. Can you bring it up? The jury can see. Ta-da.
Ta-da.
Miracles of technology.
What I'm seeing is what the jury is seeing?
Yeah, the jury sees that.
Okay, so if you go from the bottom, you can see, tension, headache, sprain, and so on. As you go up, then you see non-terminal cancer, chronic back pain, and as you keep going up, prepared childbirth is number 32, and then you keep going up, and then you come to amputation of a digit is 39, and then so forth, and then finally CRPS, often
kidney stones,
originally
42.
known as RSD, is rated as 46. So on a scale of 50, 0 to 50, CRPS is 46. Nothing is higher than that. It's such a terrible pain.
Now with this, can you tell us from your experience whether any of your patients have had, not parents, patients, but any of your patients have had difficulties going through a number of doctors before they're diagnosed?
Yes. So unfortunately, most doctors don't know about CRPS. They may have read about it and they must have blown it off as being an extremely rare condition. I don't need to bother with it. I'll probably never see it. But unfortunately, it is a very common condition. And they miss the diagnosis. They think it's an arthritic pain, or they think it's some sort of a muscle pain, and they get prescribed some of these itty-bitty pain medicines. And it was not an official study, but it was a very unofficial kind of an anecdotal article in a journal. And they said the average...
Hold on, Doc.
What's the legal basis? Sustained.
Well, just tell us what, without going into the details of any study, just tell us what the latest finding is.
Same objection, Your Honor.
What do you understand the latest, the standard, the knowledge of CRPS is, as you were about to relate?
You mean how many patients develop CRPS?
Well, that'd be interesting.
Okay, so
let's go there instead.
Well, essentially, patients go through a lot of physicians before somebody will say, you know what, I think this is CRPS. You should go and see the pain physician, and they might be able to better diagnose it.
Have you seen, or is it? The better question is it prevalent or not prevalent that when doctors cannot figure out this disease, they assign a somatic basis or a psychological basis?
Okay, so this is an interesting phenomenon. There is a difference between young women, especially, versus adults. Usually, young women, and CRPS is, by the way, very much more common in women than in men. When they present with it, it is often stamped as being psychological or anxiety or making it up or some sort of a psychiatric diagnosis. Like you really don't have pain, you're just seeking attention. In adults, it's a whole different situation. In adults, it is taken much more seriously. They are offered different treatments and different specialists who can then look at it more carefully. And that's the big...
Go ahead.
That's the big difference between younger patients and adults.
And so what is the effect on these children, younger patients, for having their pain denied by physicians repeatedly?
Well, put yourself in their shoes. Let's say you're a 12-year-old girl who develops this CRPS in her left leg from doing, acrobatics or something, or rollerblading or something. And then now you have this severe pain, and obviously the first thing your parents are going to do is, put something on it, give you some Motrin, Aleve and all that. Doesn't go away. And now it's becoming excruciating, and it's becoming red, hot, swollen, and you can't even wear clothes. So then your parents take you to the doctor, and then the doctor again has no clue what's going on, not sure what's going on. Eventually go from doctor to doctor because they go to an orthopedic, the orthopedic sends them to a neurosurgeon, the neurosurgeon sends them to a physiatrist, and it continues the cycle, and eventually they'll get to one person, and that one person will say, I know this condition, it's CRPS, and then they go on to, getting the treatment that they need.
So now once, what I'd like to go through now, if we could, and for this, I don't think counsel has an objection to the actual the pictures. That was not part of your objection. The glial cell picture.
Objection to the
all right. So
no objection there.
Let's go to 12 if we can. Now, coming up here is something I think you provided for us to. It's an incredibly sophisticated artistry, but
that it should be in the Smithsonian. I can tell you that. Are you seeing it?
Yeah, just a second. He's getting it. I tend to jump around a lot, and so.
All right, I apologize, but that's my drawing. Okay. But that's how I think. Okay, when you have only one brain cell, that's how you think. So
one brain cell.
So I just want to, before we get into this picture, I just want to explain to you what happens in CRPS. Like, okay, we got this pain, but what is going on? So the brain is not a bunch of nerves. So if you cut open, well, my brain, you'll see only one, but if you open Attorney Whitney's brain, you'll see a ton of nerves in there. But that's not what, it's only 20% of your brain is made up of nerve fibers. The electrical wires in your brain are only 20%. The rest of it is packing material. And that packing material is known as glia, which means glue. So in the old days, the thinking was that, oh, there are these nerve wires in the brain, and to support it, you would put some packing material in there. And that was the idea, that there was glial cells and they had no other function. But now we know that they have a lot more function. And besides CRPS, they're also implicated in Alzheimer's disease and dementia and other conditions. But in any case...
Let's show the next one,
well,
the 13 here. Another beautiful sketch you've done for us.
So what happens is, this one I need to explain. If I take a pen and I stick it in my finger, a signal goes up into my brain, up my arm, into my spinal cord, into my brain. And my brain then reads it as pain. And I yell out, pull the pen out, I rub it, it feels better. Everybody goes back to their business. But if I take a pen and I keep sticking it into my finger again and again and again and again for 24 hours a day, then there's a barrage of pain signals that are going to my brain, and there's a barrage of pain signals coming down. This traffic of pain signals activates the glial cells. These glial cells get upset. They get angry. And when they get angry, we can
let's show
go to the
14
next slide. When they get angry, they release chemicals. These are called chemical inflammatory mediators, which means that they produce chemicals that cause the nerves. Because remember, these glial cells are around the nerves. These glial cells then, when they get angry or when they get inflamed, they then release chemicals that cause the nerves to get inflamed.
Let's go with 15. Okay.
So now the nerve is inflamed. And this is the basic mechanism by which a lot of chronic pain can be explained, but this is the basic mechanism behind which CRPS is explained. So what I'm trying to say is that CRPS pain, so if I have CRPS in my left leg, it doesn't live in my left leg, it lives in my brain. So you could essentially cut my left leg off, I would still feel the pain because the glial cells in my brain are still activated. Eventually, if you cut off my leg, eventually the glial cells are going to say, oh, we're getting no more signals, and then they calm down, but that's a different story. So the treatment for these glial cells to calm down is, all treatments that we do are to make these glial cells calm down, so that they're not as angry.
Do we know why the glial cells get angry yet?
We're not 100% sure why they get inflamed, but one of the theories is pain that comes on from CRPS. The repetitive pain signals going to the brain cause these glial cells to get inflamed.
And can this process, the CRPS, glial cell aggravation, start in some patients from an emotional event?
So once these glial cells are inflamed and you're in the process of treating them and they're starting to calm down, like not all of them calm down at the same time. Some calm down and some don't, and say 20% will calm down first. But if there's a triggering event like, let's say, emotional stress or physical stress, then these glial cells go back to getting inflamed again.
And so does that happen every time, or is that, again, kind of a hit or miss on whether it's going to happen?
That's a difficult question to answer because there's a lot we don't know why this is happening. So it's depending on the stress, okay, I have an exam coming up, the glial cells are probably not going to get activated. But if somebody came and punched me in the nose, then I guess the glial cells would get activated.
And through the course of this, and we'll get back to the examination in a moment, but through the course of this, have you had the opportunity to review the Johns Hopkins records pertinent to this case?
Yes.
And can you explain to the jury in terms of this, some of the cells being activated, some of the cells being not, the problem with interrupting a treatment process?
So I have to go, in order for me to explain that, I have to go a bit outside the Johns Hopkins treatment paradigm.
Go ahead.
So in this case, she was getting her treatments, okay. She was seeing doctors, the doctors were giving her drugs, and she was starting to, there's a whole algorithm. It's not just simply giving ketamine or some one drug and magically everything disappears. So she was slowly starting to get better and much more active. And then what happened was at the Johns Hopkins, all of this was suddenly stopped. And when it stopped midway. It stopped at a point where she was improving, everything was stopped, and the glial activation came back, her pain came back, and plus the stress, the emotional and the physical stress. Remember, one of the things I told you about CRPS was that this is pain to touch. So it's not as simple. Even the slightest touch causes pain. But the problem is that if I have CRPS in this hand, and if I touch it lightly, the whole hand hurts. And it continues to hurt for weeks. And what was happening at the hospital was everybody walking by would touch her. I'm not sure why, to test her, to examine her, for whatever reason. Various people would touch her again and again at different places. And each time they did that, it was triggering the pain again. And remember the barrage of pain signals going up to the brain that would cause the glial cells to get inflamed? That would keep repeating again and again.
Is that one of the reasons why well, let me ask you, do you have an opinion based upon your background, training, and experience, and from your examination of Maya and your review of the records in this case, as to whether the treatment she received at Johns Hopkins All-Children's Hospital in October, November, December of 2016, and then into January of 2017, whether that permanently aggravated Maya's CRPS?
Is that the time when she was sequestered in the hospital?
Correct.
Yes, that did.
And that what you just explained, is that the reason why the glial cells had not fully gone back to normal at the time it was interrupted?
Right. So
objection. I would like to
approach, please. There's an objection, and they're going to approach, and they have paperwork. This might be a little bit longer. Let's see how long it takes to sort this one out. This doctor's a little bit funny. I think he might be a little bit too quick to try to make a joke, and the self-deprecation would be when you're hunting things, right? Self-deprecation, saying he only has one brain cell and everyone else has a lot. I do like his artwork, though. I think I'm envisioning his drawings with the nerve and the glia around it, and the saying, a little saying, "You're getting on my only nerve," or "You're getting on my last nerve" next to it. I think that would be a great item. Maybe on a coffee cup. Oh yeah. All right. This is the critical point in this testimony. They're trying to possibly just break up the testimony because he's for an expert. First of all, he's explaining things on a level and in a way that those of us who are are not familiar with any of this can understand and follow. He's giving examples that we can relate to. He's leading us along just fine as far as that goes. Mary Murphy, I made a mistake. I thought the flowers were supposed to be delivered today. They're not going to be delivered till the 2nd. So we've got, I think it'll be Monday, if I've done my math right. They should be delivered by Monday. I don't know, maybe they'll get there early, but I thought I put the 22nd, and apparently the date I had selected initially, which was the 2nd, which I think is her birthday. Is that Judge Boyd's birthday? There are purple ones on there. It should be in a purple vase, Deanne. Let me just look. I don't see... I don't see the purple flowers yet. Well, let's see. She has a whole bunch of lilies that were delivered. Those are new, but that's not the... and there's a card at the bottom of it. It's in a clear vase at the back. That was not the display that we ordered. So ours had a lot more purple in it, I think. But 11/2, so we're a month before her birthday. That's good. I think that's good. November 2nd is her birthday. I would hate to have flowers interrupt. There may be special people in her life that sent her a bouquet, and I'd hate to have our bouquet, which is big and quite huge. It's hard to miss. Push people who just mean a ton to her in her life. If her mom sends her some flowers or something. So I'd hate to intrude on that. Where are you seeing the flowers? Megan, sorry, we're talking about Judge Boyd, who is a different judge. Judge Stephanie Boyd is a judge we follow frequently when we court hop, when we go from one small courtroom around the country to another. She's a judge out of Bexar County, Texas, Bexar, Bexar County. We've watched quite a few appearances before her, as well as a full trial with her, and she has usually a purse, a very expensive purse that her mom buys her, and flowers on the screen behind her. She has her own YouTube channel, and so we sent her some flowers. They're going to be arriving.
Jury, I'm going to overrule that objection.
Oh, so that was a win. That was a win for the plaintiff.
You might need to re-ask the question.
A rare win for the plaintiff.
You didn't remember every single word of that? All right. Do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, based on your review of the records, which we'll get into in a moment, and your examination of Maya Kowalski, as to whether the interruption of her treatment process at Johns Hopkins aggravated this process and thus her CRPS?
Yes, without a question.
Okay, that's big.
And can you tell the jury whether... I need to lay a predicate. Are you aware
Remind
of
me to tell you why they asked the question that way.
Symptoms that Maya Kowalski suffered from at Johns Hopkins Children's Hospital?
I mean, I don't remember them off the top of my head, but I do remember reading about them.
Okay.
But it's not surprising if a 10-year-old girl with severe excruciating body-wide pain is segregated from her parents would develop psychological issues.
And again, can an emotional situation like that trigger aggravation of CRPS in the future?
Object to the same objection, Your Honor, and I'm happy to crunch again if you want.
I'm going to overrule that question.
But just to protect the record regarding future carrier review.
I understand. Okay. I'm overruling the objection.
Wow.
So, yes, like I said, the brain is a very intricate structure, and it's not simply saying that, okay, it's dealing with pain, structural pain from the leg. It's more than that. It's connected to many other emotional things. Pain and emotion go much together, hand in hand. And so, if your emotion, you're in this world's worst excruciating pain, and imagine you have a child that's 10 years old, has this world's excruciating pain, is now separated from you, put into a hospital that you cannot go and see, or even your family cannot see, the child is going to go through a lot of emotional stress, and that itself would trigger her pain. Well, for one, it was interrupted. For second, the emotional stress of having not exactly very friendly people come in every time, and people who weren't listening to her, people who were not paying attention to her pain, people who were not treating her pain, was stressing her out, and that was causing a lot of her pain to flare up.
The answer stands.
Let's get back to your examination now. And I believe with the court's permission, you may refer to the document and evidence, your report. Explain to the jury the results of your physical examination. And first, was this down here, or was this up at Brown University or the Pain Center?
Rhode Island. This was in Rhode Island.
Okay. All right.
Yes.
All right. And
the smallest state with the longest name. It's Rhode Island and Providence Plantations.
So, all right. So, who arrived there at your offices?
This was back in January of 2017, and Jack, her father, was there, and I believe her little brother was there.
Mm-hmm.
He was there too, and that's it.
Okay, because Beata had already
passed.
And so tell the jury the results of your examination. What did you do, and what did you find?
All right, so the whole exam took 5 hours and 22 minutes. Get ready for the 5 hours and 22 minutes of court time. I'm going to shorten that down. The first thing I did was I took a history. I asked her what was going on, and what was the problem and all that stuff. And then I started to examine her, and that's standard for any medicine. First, take a history and what treatments have been tried, what worked, what didn't work, and all that stuff. Then I did an exam directed towards her painful areas, and she described kind of a diffuse body-wide pain, and she reported pain to soft touch. And that's a classical symptom of CRPS. Soft touch meaning it's just the softest of touch causes a severe excruciating pain. Both her feet were internally rotated, so both the feet were turned in like that, and it was a constant pain that never goes down to 0 or 10. Okay, I'm going to continue. So
please do. I'm just trying to find a next exhibit.
Okay, so it's a constant pain. It never goes down to 0. That's another feature of CRPS we always ask is, does this pain ever go down to 0? And they'll always tell you no. In fact, their pain is always 10 out of 10. On a good day, on a very good, rare day, it'll be 9 or 10. That's how severe this pain is. And then I asked her if it spontaneously shoots up. You're just watching TV, you're doing nothing, and it shoots up. And she said, yes, it does. The pain increases with any physical therapy. Whenever someone touches her leg,
the witness is distracted by the paper shuffling.
She did notice. I'm sorry, I'm reading her history. You want my exam?
I wanted to show the jury photo 2529-061 in evidence. It's a photo of Maya Kowalski. I'll just show you. Dated November 19th, 2015. Go ahead. May we show it? Display it.
Is it in evidence?
It is in evidence.
Yes.
All right. Now, I'll represent to you the record shows that at that date, Maya was undergoing her procedure in Mexico, and that she was under general anesthetic. Why is that important in light of the allegations made by Johns Hopkins that she was faking her feet
Objection,
being
Your
turned?
Honor. Move to strike.
What, if anything, is significant about her feet being turned in while she's under general anesthetic?
So your feet get turned in because the muscles that control your feet are in a spasm. That's what happens. And
This is proof that she
if
wasn't
someone
faking.
is, quote unquote, faking it, then they wouldn't be doing it if they were under general anesthesia, because now they're not awake, they're asleep, and her muscles were still contracting.
So she had no control over it and they were still contracted?
That's correct.
And that tells you what about it in terms of it being voluntary or involuntary?
It's completely involuntary.
Okay. Please continue on with your examination.
Okay, so I apologize. My first part was not the exam. The exam part was, so she had diffuse pain to touch to both legs, and as well as the upper extremities. On the legs, the pain to touch extended from the front of her thigh to the side of the thigh and to the back of the thigh. So basically all around the thigh, extending over the knees. So even her knees had pain to touch, and then it went down to her lower legs, below the knees, up to the top of the feet. Then she had pain to touch to the front of the left shoulder, above the collarbone and below the collarbone, side of the shoulder, going down the arm, into the forearm, up to the hands, but she didn't have it in the hands.
Is that significant?
She didn't have pain to touch in her hands.
No.
But up to the wrist she had it.
Because the muscles
Then
would
I checked her
relax.
temperature. So I used one of those laser thingies, and I checked her temperature. The temperature to the left thigh, the left front of the thigh, was 87 degrees, and the right was 89 degrees. So there was a difference of 2 degrees.
Is that important? That's significant, that amount of temperature change?
Yes, according to the criteria, which is known as the Budapest criteria, a 1 degree difference is considered significant. Then I measured the temperature of her leg of the left leg below the knee, and that was 82 degrees, and on the right it was 83 degrees, a difference of 1 degree. The temperature to the left arm, so this is called the arm, it was, I didn't mean to, what I meant was that in medical terminology, this part is called arm, this is called forearm. In lay terms, of course, we call that the whole arm. But the upper arm was 92 degrees, and on the right side it was 99 degrees. There's a whole 7 degrees difference. Left forearm was 92 degrees, right forearm was also 99 degrees. And this was all done without touching her. Because when you touch them, then they have pain, and then you don't get the right readings. So to be sure that she was, if someone is faking it, let's put it like that. Let's just say someone is pretending or faking it, and they say like, I have weakness in my leg. What we do is we measure the circumference of that leg or the arm, and see if the muscle has atrophied or the muscle has shrunk. So I took a tape and I measured her left thigh, and it was 11 inches. And the right thigh was 12 inches. So there's a whole 1 inch difference between her left thigh and her right thigh. I measured the left lower leg, and it was 8 inches. Whereas the right lower leg was 9 inches, so a 1 inch difference. The color change between the two sides was not very obvious. It was mild, it wasn't like glaring. And that color change happens when they're in an acute flare-up. So if I had touched her and I had aggravated her pain, the color change becomes more obvious, which I had not done, obviously.
Let me show you a photo. See if I've got it here, of Maya. Yes, here it is. The knee. And do we have the one? Can you find the ones with the hand? Her hand was up. Okay.
Maya's breathing
this
seems
is in evidence
elevated.
as trial exhibit 2604-021.
Like this is difficult for her to hear.
And the date of this is January 6th, 2017. Still at Johns Hopkins. May I approach, Your Honor?
You may.
Attorney keeps walking away from the microphone. I'm trying to adjust as well as I can.
I keep forgetting I'm old school. Okay. What's significant about the knees here?
So you can see how her knees are different colored. In fact, the left knee is a little darker than the right, but they're pretty much the same. And this is a kind of a significant change, but if you aggravate the pain, this change becomes far more significant, far more prominent.
Talk to us about lesions.
Well, let me just finish my exam and then I can go on to the lesions.
I apologize, doctor. Sorry.
And both her feet, as you all saw, both her feet were internally rotated. Now, I wanted to see...
Oh, I found it. Sorry. It's 2604-014. Sorry, doctor. I keep interrupting you. I know.
There's
Direct
gonna
you to
be
the hands here.
$1 charge for every time you interrupt me. So the legs were in... Time to make some money, right? So her legs were internally rotated, okay? And I looked at why they were internally rotated. I tried to straighten them out. They straightened them out, and then they rotated back in, and I could feel the muscles were in a tight spasm.
This is another photograph from this day, which we will discuss later, of Maya being photographed. What, if any, significance is there to the hand?
You can see that how her hands turned dark red in color. It would have been nice if he had both hands, but you can see.
I'm looking for it. I'll do my best. And I'll represent to you it was on both once I can find it.
There's $1 for him interrupting me again. She did have skin lesions. Now, in CRPS, one of the things they have, I told you skin changes, right? One of the things they have is they have these, it could be anything from a small dot to a big balloon-like blister to a long line skin lesions. And the difference between this CRPS skin lesion and any other skin lesion is that this skin lesion is not itchy. The CRPS skin lesion does not itch, but it is excruciatingly painful. If you have a skin lesion from something else, like you bumped your leg against something or whatever, that would be more itchy, but not as painful. The one from the CRPS skin lesions are not itchy, but very painful.
All right, and these lesions can appear different parts of the body?
Yes, they can appear anywhere. They don't have to be on the affected area.
Is one of the significant things here about them that it takes quite a while to heal?
Yeah, so these skin lesions were a mystery to all of us in the medical world. Like, what's going on here? We didn't know what was going on. So they actually from some of the patients who had big blisters, they actually took some fluid out of there and they examined it, and it turned out to be that there was inflammatory fluid there. And so we knew that this was part of the inflammation from CRPS.
Let me show you, and with the court's permission, they are in evidence, trial exhibit 2571-030 and 2571-053. And I'll represent to you that one is a picture of Maya's forehead and hands on Christmas Eve, 2016, December 24th. And the other one of just her forehead is on January 5th, 2017. And if my math is correct, that's a difference of what, 11 days? 12 days.
So So, ladies and gentlemen, if you look at the picture on the left side, which she's holding up her hands, that little dot there on both her hands, the one on the forehead, these are classical CRPS lesions, and these are extremely. So she has pain in the arm. We know that. That's the CRPS pain, but the lesion that she has is extra painful, and she has one on the forehead, and then she has one on each hand.
Let me show you then one from even now. Oh, so this does it appear to you, doctor, that this lesion had lasted for 10 days? This one on the forehead, based on the different dates of the photographs.
That it doesn't. No, you can't make a decision whether that's a CRPS lesion because it lasted 10 days. You can't.
But do they heal up magically in 10 days, or do they, if something stays, is it indicative that it is a CRPS lesion?
It does stay for a long time, but we don't know. Like,
how long?
I don't have a number for that.
Okay. And I'll ask you to take a look at one earlier on the, I think it's the knee, and it's 2571-001, dated October 1st, 2016. I believe there's two of those, one healing and the other one, why the difference here?
Right. So obviously everyone can see that big line there, but right next to that line you'll see another lightish spot. That's right. That spot is a healing CRPS lesion, and this one it started at the part where the skin is broken. I'm talking about the long one. It started where it broke, where the skin broke, and then it kind of continued. And this is not a continuous line. It's a series of blisters, and they've all connected to each other to form a line. But you can see little bumps everywhere. It's not like a scratched line. It's more like little blisters all in a line.
Okay. Let's return to your examination. I promise I will not interrupt you if you'll let me know when you're done.
I've already made a few dollars. $3 so far. Okay. Actually, that was my examination. That's.
Ta-da.
But I did see skin lesions, and so she had multiple skin lesions, and they were, and I asked her, were they itchy? And she said, no, they weren't itchy. I asked her permission if I could touch one of them, and she said, please don't touch too hard. And then okay, fine. I just touched it very lightly, and it was painful. And the question that I had for her was, is this your usual CRPS pain, or is this particularly a much more severe pain? And she said, yes. The lesion itself was much more severely painful.
All right. So do you have an opinion based upon your background, training, and experience into a reasonable medical probability
This is the big one.
whether Maya Kowalski, over this period of time, had, and I'm talking about October, November, December of 2016, January 2017 when you saw her, do you have an opinion as to whether she had CRPS?
Yes. So my diagnosis at that point was complex regional pain syndrome, that's CRPS, type 1, to both upper and lower extremities.
Okay. So then, having done the examination, did you review the tall stack of medical records?
Yes, I did. Starting from, I believe, 2010. And I went all the way to it's like 3 weekends. Yeah, approximately 2017.
Right.
So 7 years of records.
And since 2017, have you, although I don't believe you've been able to formally examine Maya Kowalski, is that right? Or since 2017?
No, I haven't seen Maya Kowalski since that day.
Okay. Have you kept up with her informally, though, as to her condition, how she's doing?
No, not really.
All right. So let me ask you to assume, for the purposes of this question, that Maya Kowalski has continued to have relapses, one in November of 2020, and the evidence will show that she has small relapses from time to time. Let me ask you to assume that, and that she is now some 17 years old. Do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, and based on those assumptions, as to whether Maya's aggravation is a permanent condition?
Objection, same objection.
I'm just asking for permanency on a hypothetical.
I think we need to approach on that one.
You do approach. Well, we have a little break. Let me talk a little bit. There was a previous objection where they had asked a question that seemed to be very routine as they were moving along, and I wish I'd recorded what the question was. I forgot to type it down. But there was an approach, and the judge sided with the plaintiff. And then they said, re-ask the question. The plaintiff then, if you can imagine, in American football, if you're the quarterback and the opposing team jumps off the line and they're offsides when you hike the ball, you have a scenario where you basically have a free play because the other team did something wrong, and the ref is going to say, hey, because they did something wrong, you get to do this over. So you can shoot for the moon in that moment. And oftentimes you see, it's a free play. They might, throw a really risky ball downstream into heavy coverage because even if it gets intercepted, it's going to be overturned because the other team made that preliminary mistake. And this in court, with that judge making the ruling saying, hey, I'm overruling this, they can ask this. The question was asked and it was sort of expanded on, right? So he went back and he inserted all to the reasonable degree of professional certainty. According to your expert opinion, he really weighted that question down as much as he can to get the most mileage out of it because he had that free play from the judge saying, hey, it's overruled. And so he got that huge response, which was amazing. It was good lawyering right there. It was really good. And we might see that again if the objection here is overruled, where they'll get as much as they possibly can and maybe even expand the question beyond what the initial was, just to try to get that extra inch, the extra yard in the football terminology of movement down the field towards their goal. I think that's all I wanted to talk about that one. Oh my goodness, this doctor on the stand, clearly bedside manner has got to be 10 out of 10. There's no question as to why he won that huge award for the way he provides service and compassionate care. His bedside manner and just the way he approaches and feels and understands his patients is wonderful. So I bet everybody loves him. We'll see. The doctor, I bet you're going to see some humor as the doctor interacts with the defense as well. I think this is his style. He's not going to turn into the mean guy who's going to be, very defensive on this. I think you're going to see that same level of humor if the opportunity presents itself when he's under cross-examination as well, even though the defense is going to go for the throat here. They've got to regain some ground because they've lost some big little battles. So, I mean, the war's not over, but they lost some big little battles to this point. Bedside manner is crucial for recovery. There are so many things, and honestly, it's hard to put this. Science can't put a factor on it, but there are so many things that can be done that aren't measurable in a patient's care that can improve the outcome. And bedside manner, I would argue, is one of those. Having a patient that getting the patient to laugh, getting the patient to smile, to have some hope. It's not a medicine, so to speak, but the laughter is the best medicine. It pays off. This doctor has got it in spades. His classes must be a blast. If we can ever get into his Ivy League school to take them. I'm going to try to grab the soundbite. I think it was at 3:05, 3 hours and 5 minutes into the live stream that we had the first comment about I'm going to charge you $1 per interruption. Few people in court today appear to be observers. Not sure. Not sure if there are any significance as far as who's there. The gentleman in the back in the corner has been there before. He likes that little seat in the back corner. I think he likes to lean against the wall and maybe rest a bit. Sustained. Bummer.
Based upon your background, training, and experience, and to a reasonable medical certainty, is CRPS a permanent condition?
Yes, in almost most cases. When I say that, I mean almost 90% of cases, it is a permanent condition.
And in your clinical experience, are patients who have had this type of aggravation where the glial cell recovery has been interrupted, does that increase the likelihood that the condition will be permanent?
Same objection.
Overruled on that one.
So, it's like any other wound. The wound, I have let's say I have a nasty wound on my hand and it eventually heals and closes up. But then if while it's closing up, while it's healing up, I go and, hit it again. It opens up, the whole process again starts to heal up, and then I hit it again, and then it starts to, and that's exactly what happens in CRPS is if you repeatedly aggravate the pain, whichever way, physically or mentally, if you aggravate the pain, the brain changes that happen go back to the same thing. The cells getting inflamed and the nerves getting inflamed goes back to it.
All right.
This is cumulative from the start of
your background,
testimony.
Training, and experience, and to a reasonable medical probability from your review of this case as to whether those physicians at Johns Hopkins All Children's Hospital in October of 2016 deviated from the accepted standard of care by failing to diagnose and subsequently then questioning whether Maya Kowalski had CRPS.
Objection.
There it is.
Just a very brief approach on this, Your Honor.
There's an order on that.
I'm going to overrule the objection. No need to approach.
Okay.
Boom.
You can testify. Go
I
ahead.
can?
Yeah.
Okay. So what happened is, you have to imagine this thing. This is not something that's written and you just read it. Okay, you have to imagine what's happening. Here you have a 10-year-old girl who has this horrible, excruciating, body-wide burning pain. She's got these skin lesions, and which is a big deal for a 10-year-old girl. And now you're also isolated from your loved ones, and you have people coming and seeing you every day, all day long. People who are not friendly.
Your Honor, this is non-responsive to the question.
That'll be sustained.
I think it's a predicate.
Overruled. You can continue your answer.
These people are they're not there to help her. They're not trying to help her. They're trying to actually question that if she really has pain. And, they're touching her again and again and again. They're putting her into physical therapy, which she's trying. It's not like she did not try it. She did try physical therapy. She did what they said. She was not improving at all. And this, I really think, is what aggravated her condition.
And so was that a yes? They breached the duty of reasonable care and deviated from the accepted standard of care?
Yes, absolutely.
Boom.
All right.
That's it.
And we actually have a short video we previously discussed at 2703-D from October 20th, 2016. Judge, may I publish this? It's short. It's,
You may.
I don't know, it's only about 30 seconds. Not even that.
Is there some?
Your text messages coming
And
out.
after it's over, Doctor, I'm going to ask you to point out here the
We're
significance
joking
of
about
the
this,
body
but I'm wondering if there's a thought about a mid-court settlement at this point. That testimony is so huge. You've got a doctor that 99% of the time you're going to say, looking at this, the jury is on board with the doctor. They like the doctor. He's friendly. He's explained everything in a way they understand. He's come across as very credible. He's extremely experienced. And he just said, yes, the hospital breached the standard of care, which basically is what the whole allegation is. Okay, the defense table is they're up a creek without a paddle at this point on this issue. So unless they can regain this ground some way and claw it back, and it will be a fight to get this back, this was a huge win, and arguably the first huge win that the plaintiffs have received in this. I think Jack knows it. And he's writing a note.
Just need a moment or two, please.
Okay, let me ask some more questions.
Yes, please.
I'll take you off the firing line there. Okay. We're going to come back as soon as the technicals get that rolling. All right, so let's talk a little bit about ketamine. In your practice, have you been able to
the fact that they grabbed the phone and sent a
familiarize
text after they
yourself
all
with the use
talked to
of
each other?
ketamine as a treatment for CRPS?
Yes, I'm very familiar with the use of ketamine for the last 30 years because this is something that we use in the operating room, in the intensive care unit, emergency rooms. We use it on the field.
Can you tell us some instances, by way of foundation predicate here, of instances where you have made a decision to use ketamine as the drug of choice, and any emergency situations that can perhaps explain to the jury the safety of the drug?
Ketamine is probably one of the most safe, I'm sorry, wrong English. It's probably the safest drug that you can use under any circumstances. So, as we speak right now, first responders all have ketamine with them. When they have a patient with an acute injury, or when they have a patient with asthma, it works on asthma. A patient with severe asthma, all they do is they shoot some ketamine and it improves. They shoot some ketamine and the fracture site can be stabilized. It helps their pain. If they're bleeding out, it helps with shock. Now, I mean, I've worked in the operating rooms. Obviously, I've used ketamine a lot. I've worked in the ICU where we used ketamine for patients who had severe asthma. I mean, this asthma was so severe that there was no air moving in and out, and there was no question that giving them the steroid would make a big difference. We would give them ketamine, their airway would open up instantly. There was one incident I really want to share to you how safe this drug is. It was a while ago. I was back in India. I was on call. I can say that story.
Yes, you can tell the story.
I was on call at a hospital. It was a teaching hospital. I was on call that night. It was on midnight.
I object to the narrative on this. Really.
This is about this is just a predicate and the use of ketamine, his experience.
I'm going to allow it.
You can,
okay.
Yeah, you can talk.
Okay. We get a call and there was a train accident. Two trains, an up train and the down train, with passengers on it, had a head-on collision. So they had a head-on collision. When I got there, the trains were looking up like that. There was twisted steel everywhere. There were passengers that were trapped under like tons of steel. There was no way that we could remove all that steel with jaws of life or anything like that. And even if we did, they would have died from bleeding but then and there. We were giving these passengers ketamine injections right there. We had no access to the patient. We had no access to their airway. But because ketamine increases your breathing, increases your blood pressure, we would give them ketamine. It would take them out of their shock. The surgeon could do an amputation and remove them. And I think that night, just from ketamine, we must have saved about 300 or 400 lives. And these are patients we could barely see even or know anything about it. Ketamine, it would take care of the shock, it would take care of their breathing, and it would take care of their pain.
I found out that 2703D, the photo during the video, well, let's just go ahead and play it, and I'd like you to pay close attention to the body movements here.
Watching the text messages from the lawyer in blue on the end.
$1, yeah. Like normally $1.50, but the more shopping the better. Oh really?
Then she has your medicine, which should be helping a little bit. I want to try to use the walker just to stand, pivot, get in the chair, like you did with that the other day. So I'm jealous that she got to see it and I did not. So I'm going to help you, but I want you to try to get your feet flat on the ground. And I'll hold you up and see your feet flat. Put your feet down. There you go. Good job. Turn the walker. You got it. Better than yesterday. Hey, give me a high five. That was awesome. Better than yesterday. I wish we had the feet video. That was awesome. Great job.
It's going to hurt just a little bit because you haven't put any weight on the leg. No.
Okay. This depicts them trying to get her to walk with a walker. What did you notice about body position and legs, and so forth?
So she has no motor strength to both her legs. I mean, she's trying to stand, and she actually tried 2 or 3 times to try and stand, and each time her knees buckled, and she had no motor strength at all.
Were you able to hear her moans in the background?
Yes, she was.
It appeared to you that she was in pain. Did it appear to you that she was...
I'm sorry. Yes, I was looking at the video. Yes, she was. Absolutely, she was in pain.
Okay. Let's get back now to ketamine, and let's talk a little bit. We've established that it is a safe drug. And by the way, in your 30 years of practice or more? How long have you been practicing?
Well,
I'll answer this in the next break.
I've been a doctor for about 30 years now.
Okay. To the best of your knowledge, has any patient ever died from the medical administration of ketamine?
Thank you for covering
Never.
this case.
Has anyone, a patient, suffered a permanent injury from the medical administration of ketamine?
Never.
And would that include patients that have been titrated up above, say, 1,000 milligrams or more per hour?
Yes.
So let's talk then a little bit about the dosing of ketamine, particularly for complex regional pain disorder syndrome.
12-hour shift is not easy.
And particularly with Maya. And I'm interested, if you could, in explaining the concept of titration to the jury.
So the concept of titration works in pain medicine. It works. The way we do that is, say somebody comes to me and has pain in their hip. They have pain in their hip, and we've tried everything, nothing's working. We give them a small 1 pill of a pain medicine, okay, and we try to see the response to it. And if the patient comes back and says, "Hey doc, it helped for some time, only for a couple of hours, but I still have pain for the rest of the day," we increase it to 2 pills a day. And the same thing when the patient comes back and they've had some good response, but not a we're looking for function. We're not looking for zero pain. That's in pain medicine. Even in medicine, we don't look for zero pain. We look for functional. And so he's somewhat functional, but not enough. So we go up by another dose. And so forth, we go up very slowly, step by step. It's the same principle used in seizures also. You start at a very small dose, and it's called start low, go slow. You start at a small dose, and you slowly titrate up. And in pain medicine, we do the same thing because we don't know how much you're going to take. I might give you a tablet for your head, a Tylenol for your headache, and it'll go away. I might need 4. Actually, I might need 4 right now. But it might, I'm sure all of you guys need 4. But it might, so we don't know. And so the way we do it is because we don't know, I'm not going to give somebody I'm not going to give them 4 tablets of Tylenol and say, hey, take this. I'm going to give them 1, and if they're not happy with it, I'll give them another one and another one till they get to a point like, okay, now I can tolerate listening to testimony from me.
Is that known as a therapeutic dose?
Yes, the therapeutic dose for that patient.
All right. And so in Maya's case now, are you aware of, because of her asthma, she was taking any medications that might affect, or did affect rather, the amount of ketamine it took to bring her to a therapeutic dose?
All right, so this question I have to answer with a little bit of science in it, in that any drug that we take is destroyed by a chemical in our body called enzyme. So there are enzymes in my body that destroy any chemical. For example, if I take a Tylenol, there is an enzyme that burns up the Tylenol. And the reason is to protect me because, if I take one Tylenol, it'll continue to exist for the rest of my life. So that not to avoid that happening, there are enzymes that destroy it, and then it's thrown out by the kidneys or the stool. In Maya's case, she was on massive, that's a whole different subject to talk about, but she was on massive doses of steroids for her asthma. And those steroids were revving up one of these enzymes called, which really hard for me to remember, it's called the CP2D6. And what it does is
is that otherwise known as P450?
P450, it revs up that enzyme. Now, this is the same enzyme that also destroys ketamine. So now you're actually burning up the ketamine faster because she's on the steroid. The steroid revs up this enzyme, and this enzyme, by the way, also destroys ketamine. And so she's burning up the ketamine. And so her requirement for ketamine kept increasing, and that's one of the reasons.
So do you have an opinion based upon your background, training, experience to a reasonable medical probability as to whether the ER docs that first saw Maya in October of 2016, including Dr. Farhan Malik, Dr. Beatrice Tepa-Sanchez, deviated from the accepted standard of care by not researching more fully and confirming any reasons why Maya would be taking larger doses than they expect?
Renew the objection.
This could be overruled.
Mr. Court Reporter, may I have that question read back, please?
Wow. First time we've had this question read back. It was a long question.
So do you have an opinion based upon your background, training, and experience to a reasonable medical probability as to whether the ER docs that first saw Maya in October of 16, including Dr. Farhan Malik, Dr. Beatrice
Tepa-Sanchez,
deviated from the accepted standard of care by not researching more fully and confirming any reasons why Maya would be taking larger doses than they expected?
I'm going to overrule the objection. The witness may answer.
Yes, they deviated from because this is something standard. They are the ones who are giving her massive dose of steroid, and they should know what the side effects of these steroids are in respect to ketamine.
Double whammy. Boom, boom.
In fact, from your review of the records at Johns Hopkins, at least for a period of time initially, did they maintain her on those steroids? Do you know? If you don't know, it's okay.
I don't know. I don't remember.
There's a lot to remember in this case. All right. So did it come to your attention that in this particular admission on October 7th of 2016, whether immediately thereafter, they put Maya right back on ketamine at Johns Hopkins Hospital.
No, they, as far as I recall, they did not start her on ketamine right away.
Well, actually, we know they didn't keep her on ketamine, but in the first day or two. I'll show you the records. How about that?
Okay.
It might be a little easier. All right. Now, in terms of treatment of CRPS in the future, what is your opinion about what somebody who has had CRPS diagnosed and then aggravated, what can they expect in the future to a reasonable medical probability?
Same objection.
I don't know.
I'm going to overrule that objection.
So, if someone has had CRPS, I tell them, and we all tell them, that this is a lifelong condition. In fact, it is so surgeons will refuse to operate on a patient once they find out that the patient has had CRPS ever in their life. That's how scary this is.
Is it listed as one of the 11, I'm going to owe you another $1, one of the 11 essential drugs of the World Health Organization?
Yes, it is.
Please continue, I'll pay your $1.
So the World Health Organization has a list of essential drugs that every country must have, and ketamine is one of them.
So please continue.
Yeah, you need to put $1 in the tip jar.
Yeah, I know.
So
you're going to own me by the end.
So CRPS is a lifelong condition. Okay. Now let's say we've done the treatment, we've done everything, and the patient is doing better. Okay. Now better means more good days than bad days. That's better in their lives. And so they still have to be extremely careful of aggravating it. They cannot afford to have any injury. They cannot afford to have a lot of stress in their lives. If they ever go in for surgery, then they have to take extra special precautions. Naturally, one of the precautions is that the anesthesiologist has to give them ketamine during the surgery, after the surgery, and continue into the post-operative period, because that's the only drug that works on this. Most surgeons will refuse to do surgery if the patient has a history of CRPS. That's how severe this is considered in the medical world.
So does that prevent, in many instances, the patient from getting the appropriate treatment in the event of an accident or something like that?
Well, in the event of an accident, of course, they have to do what they have to do. But if Maya were to have a surgery that is kind of maybe optional, let's say she has a bone that hasn't healed well and has to be straightened out, the surgeon won't do it.
Now, I have to ask these questions in follow-up to the two questions about the deviations from the accepted standard of care. Just to be safe here, Doctor, do you have an opinion based upon your background, training, and experience and to a reasonable medical probability whether the two deviations that you've testified to here in court caused or contributed to permanent injury to Maya Kowalski?
Yes, absolutely.
Overruled. The answer stands.
One moment, Your Honor.
Okay, so the reason they asked the question, do you have an opinion? This is an expert
I know what
witness.
I wanted to ask. Is ketamine now used to treat depression and other psychological illnesses?
Yes, ketamine has now been approved. The best news about ketamine now is that it has been approved for treatment of what's called treatment-resistant depression. So these people have such severe depression that drugs are not working anymore. The normal antidepressants are not working anymore, and they get ketamine, nasal spray, or some centers will do IV ketamine. The FDA has also approved ketamine for treatment of CRPS. since 2019.
So in the event that someone, for instance, Maya, is there's testimony that she's diagnosed with a permanent psychological injury, would the ketamine be of use to her in the future?
Objection, relevance, and scope.
Tie together later based on further expert testimony as to psychological conditions.
He's to tie it together now.
What's your approach on that one?
Okay, they're going to approach. Okay, so when he says to your professional opinion, do you have an opinion? Most witnesses are only able to testify to something they've personally observed. But an expert witness can come in and can read the situation, can read the records, and can form an opinion and then share that. That's only an expert can do that. And so when they ask that question, it signifies that, hey, this is an expert, and this is a question that will only be allowed for an expert, and it allows them to speculate on things that that a normal witness would be improper for a normal witness to share. That's why they asked that question. Thank you, KKD, for the question. I don't know. I have not seen the list of witnesses. I know there are a ton of people on it. A ton of people. This is good testimony. It's been many mic drop moments. Look at the body language. We need Dr. G in here. Look at the body language of the two sides after these big wins and the mic drops occur. With Jack there writing a note to his son really quickly and showing him and the nod and then scribbling things out, as well as the worried glances between the defense as the initial testimony came out where this witness said, yes, the hospital failed the standard of care. And as those mic drop moments started beginning and they looked at each other, and then the lawyer in the light blue suit on the defense side picks up his phone, sends a quick text. So they're pointing out that they've lost something. Now, I will say this: I think that the hospital will continue. I don't think they're going to settle right here. This is not the point where you just wave the white flag and bring out the blank check, because the amount of the settlement would be based on the information that's been shared right now. I personally believe is a smaller portion. The bigger battle, which I think the hospital, honestly, if I just had to weigh it right now, that I think the hospital is winning and may actually win, is, are they liable for Beata's death? Are they liable in some way? Do they have some culpability and burden, financial responsibility?
The objection to that question is sustained.
Okay. So they might continue fighting this because the bigger portion of liability that they might face is regarding
your background training.
Beata's death.
Are you aware that Johns Hopkins Hospital during this period refused after the first couple of days, refused to allow Maya to have ketamine to help her get through this? Are you aware of that?
Yes, I am.
Do you have an opinion based upon your background training and experience into a reasonable medical probability as to whether refusing to allow a patient, Maya Kowalski in this instance, access to the most successful drugs to treat her condition is a deviation from the accepted standard of care, breach of the duty of reasonable care?
Yes.
And is it your opinion to a reasonable medical probability and based upon your background training and experience as to whether those deviations caused or contributed to injury, permanent injury to Maya Kowalski?
Renew the objection.
Overruled. You can answer.
Yes, absolutely.
Boom. That's huge. Kaboom, kaboom, kaboom. They caused the injury. They caused the injury. Because the testimony was yes. Look at this, the not happy glance from that attorney. Okay. We need a tip jar emoji. The pickle jar works for the tip jar, right? Empty pickle jar.
That's right. One more question. Can you tell the jury, based upon your background training and experience into a reasonable medical probability, whether titrating to effect in the use of ketamine is the accepted standard of care?
Oh, yes. I mean, that is without a doubt the standard of care. No question.
Your witness.
Well, given that it's 12:10, I think it's
that's time to take a break
for everybody. Members of the jury, I'm going to ask.
I think defense has lost their appetite.
Deputy Coley, I want the jury to be ready at 1:40. So at 1:40, I want them to be able to come in. So whatever time you need at the rallying point. So.
Ask the jury if they want to stay through cross, and then this is our last.
No, we're going to lunch right now. I can tell you that without a discussion at sidebar.
They want to continue this win streak.
Members of the jury, please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. I will see you after lunch. Have a good lunch.
Okay, so this has been an incredible morning as far as testimony goes. After seeing loss after loss on the objection, on the ejection score for the plaintiffs, today a couple big wins on the objections where some objections were overruled, resulted in huge testimony from arguably one of the most qualified witnesses that we're going to see in this whole trial. This guy's got he's a doctor squared. He's got his doctorate twice, once through a British program in India and once here in the United States. He's got all the experience. He's as far as specialized experience relative to this case. It's wow. It's huge. Hang on, what just happened here? What just happened? Did they just come?
You can talk about the weather, you can talk about plane flights or whatever else, but you cannot talk about the subject matter of this case or the testimony.
Absolutely.
Okay. And so I want you back here, let's say, at 1:30. Okay. So if you want to take off and go to lunch, you're free to do that at this time. Are there issues, plaintiff defense, that we need to discuss before we go?
Not unless, not prepared.
How come the defense from?
I will tell you, I've received Mr. Altenburn and Mr. Elligott's drafts with the various different objections and counter proposals. What I have here is my amalgamation of those, so basically kind of my thoughts on the matter. I'm going to hand them to you. You all can look at them. We can discuss them when we come back or perhaps after the jury leaves today. So this goes to the plaintiffs and this goes to the defense.
Thank you.
Apparently they had a little business to conduct here. Right
With the jury coming back, and I want the jury to be able to walk in at 1:40. If we come back at 1:30, which is an hour and 16, 17 minutes from now, is that enough time for us to do whatever we need to do before the jury comes? Or do we need more time?
Does that mean discuss the jury instruction, or does that mean anything else?
I think we can do the jury instruction after the jury leaves today.
Especially, I don't, are you expecting to have Mr. Elliott here?
I'm going to call him on lunch.
Okay. I think 1:30 is fine. Hopefully we can come to some type of an agreement. If not, we prefer to do that after the jury's excused for the day.
And what you'll see, the top one is the enrolled version. The bottom, I kind of left with the legislative change and my thoughts on it. You will be pretty self-evident. Okay. Everyone will be back at 1:30.
Matthew Harris, I think we just got raided by Matthew Harris. Did that just happen? Matthew, welcome. Good to have you here. Thank you so much. Okay, so we're going to lunch. This is Thursday. Matthew, I have to check. Did you drop a video today? Did you drop a new video? Typically Thursday at lunchtime is when Matthew drops his videos. Matthew, great friend of the program, wonderful lawyer, based out of Texas. And let's see, there's his channel right there, so we might have to pop over there. If you haven't, Matthew has a quiz, a daily quiz, where I'm of the firm belief, and I might be mistaken in this, but I'm of the firm belief that if I can get 100% for an entire year on that quiz, I'm ready to take the bar exam. So you can't get this sort of free legal prep for the bar exam anywhere else other than Matthew's channel. So definitely go over there, take the quiz, and check out his latest video. Matthew, did he drop one? Love his quiz. We'll see. We've got a couple comments here to talk about here as we get ready for lunch. We're going to come back in about an hour from right now. So set your watch for an hour and we'll be back. Kelly says, love this community. 2 months. Thank you very much, Kelly. Appreciate that very much. Tag also just gifted a membership as well. That one went to Kitty S. Is it Kitty S? KTEES? With a space in there. Congratulations, KTS. I'm not sure. It's the simple ones I can't pronounce. So, wonderful. Maybe the Texas bar. The Texas bar. It's a valid bar as well. If I ever pass the bar, I think it'll be in Virginia because they don't require you to go to school before you take the exam, and I'm not sure I could do it. Let's see. Matthew says video just dropped. Win without an attorney. There you go. I don't recommend this one. Testimony, objections, and evidence. You're recommending that people don't have an attorney? Man, that's a brave path to go. I would call an attorney in a heartbeat. I'd call Matthew. Okay, so this has been one of the best days of testimony in this trial so far. This has been so good. With the testimony from this doctor, Dr. Pradeep Chopra. He's a pain doctor. He's an expert on pain treatment and also an expert on the CRPS, which Maya has in this condition. That alone is him being able to identify the symptoms and saying that's clearly what it is. That's obviously what it is. This is the path that most patients who have this go until they can sort of get some treatment and they bounce from doctor to doctor. This is important testimony because Maya's family did go from doctor to doctor looking for proper treatment, but explaining how this goes and how one doctor refers to another and they end up finally getting with someone who can treat it. There it is. Matthew Harris says, unfortunately, not everyone can afford to hire me, so I'm sharing tips for those who must go it alone. Oh, that's funny. I can't wait. We'll watch that here on the lunch break. Let's see. Anyway, yes, Texas bar requires attendance at an ABA-approved law school. See, I just can't do that, Matthew. I've done my time in school. I might go back a little bit if there's something I really want to learn, but I'm not sure if I could go through law school. It'd be terrible for me anyway. For me, I don't know. I might love it anyway. So this evidence that he testified to, the way he answered, and the way he was able to do it to his professional opinion, which he already. I mean, we already knew this guy is the most qualified of doctors when it comes to talking about this. And then how he calls out the hospital, saying that they failed to meet the standard of care, they failed to diagnose, and that their treatment of Maya contributed or caused this condition, which does not go away, which goes on forever and ever. These are checking the boxes as far as this is what you want to have in testimony when you're asking for a settlement from the other side, or you were asking for a judgment against the other side. So it's massive that you've now got this testimony, which I think the jury would believe, because this hey Zoe, I'm talking about Maya. Anyway, you've got this testimony in there, which this is the case. Are you going to have somebody else that comes out and counters this doctor's opinion? And are they going to be somehow a better doctor at this specific thing? I think they've sort of played their ace card already in this trial. Now I realize the trial is slated to go for quite a while longer, we're not going to address subject matter jurisdiction. We are going to lunch. The trial is slated to go for a while longer, and there are other elements of this settlement. Specifically, the family feels that the hospital should be held financially responsible for the loss of Beata, for her taking her own life because of the hospital's actions, and they want to tie that in. And when you look at the two issues and taking the personal thing out, but just weighing the glossing over the situation, you've got a child who was diagnosed wrong and is now suffering from that for the rest of her life. That's sad. Okay, we're taking the emotion out. That's one thing. But then you also, on the other side, you have a loss of life. And the child did not lose her life, and she appears to be doing well. Honestly, that might be a detriment to their argument. on the plaintiff's side. But the loss of life is huge. The loss of income, the impact that has on the family, all three family members. If the defense can get that testimony in that the hospital should be liable for that, that's a massive win. If you're looking at mathematically at the settlement side. This is just the malpractice stage, but this is a huge win. This is a win. I think if the jury were to go out right now, even if after the defense plays, I think the defense, no matter what they put on, they've already lost a little bit in this area. So I would say the jury would return a favorable settlement in that area. But they're going for the big picture here, and the hospital still has to defend that huge liability, where if they are deemed liable for or held liable for Beata taking her own life, that could be the larger portion of the settlement, is what I'm saying. And that's why we're seeing the hospital fight so hard to get the jury instructions regarding that portion of the instruction to be favorable for their situation, or the fact pattern that is being presented in this case. All right, is that your flagpole showing? No, but it's a beautiful one. It looks like a tennis ball, but I think it's just a reflection on top. I think it would be funny if it was a tennis ball on top of the flag, but probably not appropriate from like a U.S. Regulations, like flag display regulations or something. Military regulations. We have a 1 hour lunch break. We're going to go right here now to the Court of Public Opinion, the back room where I'm at. We'll be back. Let's see. Is Maya doing well now because she's administered ketamine? I don't know. We haven't heard about presently how she's doing, and a lot of the doctors who have testified, or the people who have testified are not treating her currently. They treated her during that time, and they saw her during or before or shortly after that time. But we haven't had a lot of testimony about currently how she's doing and her health and treatment at this point. What time are we coming back? In 50 minutes, 55 minutes, or 57 or something like that. I don't know. Yes, I think they have. I think that was talked about in opening. But in the statute of limitations, it's already expired. To tag, sorry. That was, can the hospital get legal charges if they prove abandonment of care? Yeah, I don't think there will be legal criminal charges in this at all. I think it's going to stay in the civil courts. But, all right, this is spicy. And let me tell you, if you thought this morning was good, the cross-examination of this witness is coming first thing after lunch. So we're going to have that. We know also this afternoon we're going to have some legal battles outside of the jury's presence at the end of the day. That's how we're going to wrap up the day, and those are always very insightful as well. I've enjoyed those almost as much as I've enjoyed the testimony in front of the jury. It's all good stuff. We're loving it. All right, it is lunchtime. Don't want to miss this afternoon. So please click the subscribe button, ring the bell, and if you're here, before you go, if you could click the like button as well, that's always appreciated. It's free today only. Like buttons are free, so thanks very much. If they don't do well on cross, they will settle. I think they've got a bigger issue. I think they have to fight further, and they could fight all the way to the end of the trial. Okay, they could fight right towards jury deliberation, and at that point, if they really feel that they've lost this one, that it's just out of their realm, they might want to settle. But also, you run the risk of getting to the point where the family feels so confident in the win that they won't accept a settlement. So they might have to pick and choose where, if they decide to settle at this point, where they do that. Patty, you've got to complete all the adult tasks now. It's time. You've got an hour to do it. We'll be back in a little bit. All right. For those who might not be returning to us, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again in about, 50 minutes. About 50 minutes from right now. Back at 1:15 my time. I'm on the East Coast here in North Carolina. Thank you so much for joining me in the Court of Public Opinion. I will apologize for sleeping in this morning. I woke up after court had started, basically. So I'm gonna go do my morning stuff that I didn't do before I came here. I'm gonna comb my hair, look a little more presentable. Hope you guys have a wonderful lunch. I'll see you on the flip side. Thanks.
Is that correct?
Scratch all that. Oh, that was terrible. I apologize.